We're going to begin with our state all-purpose calendar. These are going to be cases in which individuals have been arrested and charged and accused of certain misdemeanor offenses. The cases have already had their initial appearance and bonds have already been set in these cases. If you are a defendant charged with one or more misdemeanor offense, please remember that you have a right to remain silent. Anything that you say during the course of this virtual proceeding, your statements can and will be used against you. So please do not discuss your case unless your attorney gives you permission to do so. You have a right to an attorney. If you cannot afford one of our attorneys from the Public Defender's Office or the Conflict Defense List will be representing you. Today, we're going to be getting a status of the cases to see how they're going to move forward. Certain individuals have already been discussing through their attorneys with the prosecutor, and perhaps they want to accept a plea offer in exchange for a guilty or no contest plea. Other cases, individuals may decide to go forward with the trial, so those cases will be arraigned today. I received the public defense list. Looks like there are quite a few cases which Mr. McLean or Mr. Doties, have you managed to locate some of your clients?
Which ones, Your Honor?
Well, let me see. Mr. Doties apparently is still trying to find positions 3, position 7, position 9, position 15, and position 18. So,
yes, Your Honor. Good morning. I just had the opportunity to interview position 7. That'll be a negotiated plea. I've been notified that a couple of the people I was unable to locate yesterday will appear on Zoom, so I will need breakout rooms. If I see anyone else in the room, then I'll work quickly to address them.
okay. So right now I've got position 3, position 9, position 15, and position 18. There are 4 more that you need to confer with. Is that correct?
I believe so, Your Honor.
All right. I'm not sure who's the deputy in courtroom 2, but hopefully we'll be able to arrange that. Okay.
Good morning, Judge Law.
Good morning, Dr. Francois. I'm so sorry you and I have to do this again. Seems like it was just yesterday, right?
Right.
Okay.
We're going to be starting with position number 19, Mr. Knight.
Okay.
In Your Honor, just so the court's aware, you'll see the screen, Richard Turnbull, that's position 35.
Okay. All right. We will get to position 19 first, and then remind me to take position 35 next. Okay. At position 19 in courtroom 2, I have State versus Elgin Knight. Mr. Knight has been accused of criminal trespass from June 29, 2021 in accusation number 22 CR 1834B. And Mr. Elgin, Mr. Knight, you've been advised of your right to remain silent, and your attorney is it Mr. McLean?
Yes.
Okay. Mr. McLean, what is the announcement for this case?
Okay. Your Honor, Mr. Knight, I'll need to speak with first. If we can go to another position.
All right. Dr. Francois, I'm just moving over to another location, and then I'll be right back with courtroom 2. We have a Richard Turnbull, position 35. And that I believe is that Mr. McLean's client as well?
Yes, Trenton Thompson, Your Honor, is just going to be, we could actually do a waiver of arraignment and presence both, and I can have that signed and sent into the court.
All right. We have Mr. Richard Turnbull actually on Zoom right now, and Mr. Turnbull, you've been advised of your right to remain silent, and no, hang on.
35 is Trenton Thompson.
Okay, is that Trenton Thompson?
That is.
Okay.
And that's-
Judge, I'm sorry. I'm Sergeant Turnbull, Richard Turnbull, and the
Got it.
inmate is right here. I'm just, acquiring the Zoom for him.
I appreciate it. Thank you so
Okay.
much, Sergeant. All right, that the state versus Trenton Thompson, accusation number 23 CR 4886G, in which he's been charged with fair evasion, tampering with evidence, and possession of a revolver or pistol by an individual under the age of 18. Mr. Thompson, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Just to confirm, Mr. McLean, you're filing a waiver of arraignment. You're waiving his presence, and you want the case further notice for jail jury. Is that correct?
That is correct, Your Honor.
Okay. Please make sure you submit your waiver of arraignment to our litigation manager, Miss April Champion. And Mr. Thompson, your case is going to be scheduled for a trial. You will receive notice of when you'll be summoned to court. Thank you.
Thank you.
Excuse me, Judge, are you finished with Mr. Thompson?
Yes, Sergeant. We
Okay.
concluded with Mr. Thompson. Thank you so much.
Okay, you're welcome, ma'am. Have a good day.
You too. Courtroom 2, who do we have next, please?
Position 22, Mr. Pate.
Okay.
Okay. 22. Okay, that would be position 21 and 22, and I gather that's going to be a plea, Mr. McLean?
That is correct, Your Honor.
All right, and the state will null pros position 22 if the matter goes forward. All right. This is State versus Adam Pate, case number 22 CR 6629H. Mr. Pate was accused of fair evasion and criminal trespass from September 30th, 2022. He also has an open case pursuant to a bench warrant, 23 FTA 774. Presently, Mr. Pate, we're going to have a plea hearing. So may I place you under oath?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Miss Helena Allen? Anna,
Me, Your Honor.
is it Miss Allen?
Yes,
All right. I wasn't sure where the hyphens was supposed to be placed.
my
Okay.
name is Anna Helena.
Oh, that's pretty. Thank you so much. Okay. Miss Allen, what is the plea offer for Mr. Pate?
21 days, time served.
Thank you. Mr. McLean, does your client accept those terms? And do you stipulate to the factual basis, venue, and ID?
He does, and we do.
All right. Mr. Pate, have you consumed any medication or alcohol?
Negative.
And was it?
Negative, he said.
Okay. And are you satisfied with your attorney?
Yes.
And has anyone forced you or induced you to take this plea offer?
Negative.
And if have in your discussions with your attorney, have you reviewed the plea sheet? The document in which you are, it's been explained to you what rights you would have to waive in order to enter a guilty plea?
Yes. Sure.
And do you agree that freely and voluntarily that if you decide to enter a guilty plea, you will be waiving your right to a trial, to go back to court, to confront your accuser, to challenge the evidence and the witnesses brought against you, and have the state try to carry its burden of proof of beyond a reasonable doubt to prove the charges against you?
Affirmative.
How do you plead to one count of fair evasion and one count of criminal trespass? Repeat.
Guilty.
I'll accept your guilty plea. Your sentence is 12 months to serve 21 days, credit for 21 days. That concludes your case. You'll be released within 24 hours unless you have any other matters holding you at the jail. Thank you.
Yes.
And position 22 will be null pros. Ms. Allen, if you please submit the null pros order to Ms. Champion, we appreciate it. Thank you.
Payne.
Next case, please.
Position 23, Mr. Ellis Payne.
This is,
Also a negotiated plea, Your Honor, involving probation and a class.
thank you very much. This is State versus Elias Payne, 23 CR 5169F. Mr. Payne was accused of theft by shoplifting from December 12, 2022 incident. Mr. Payne, you've been advised of your right to remain silent. Your attorney is Mr. McLean. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Allen?
Morning, Your Honor. I'm representing the state on this matter. This is a date of incident from 2022. Do you want me to go ahead and go into the facts?
Yes. Well, this is a negotiated plea, yes?
Right.
If Mr. McLean will stipulate to the facts, venue, and ID, then we can proceed to the proposed offer.
We do so stipulate.
Okay, Your Honor, the offer in this case is 12 months to serve, 30 days. Credit for time served, I believe it's been 15 days he's getting credit for. Complete the theft course and stay away from the incident location.
And do you have the location, please?
Yes, Your Honor. It is a Walmart
Oh.
at 970 Mansell Road in Roswell.
All right. Thank you.
The delay in arrest in this case was based on a review of the cell phone at the location in the possession of the defendant. Just took a while to analyze it.
Okay. Mr. McLean, you've already stipulated accordingly, and does your client accept these terms?
He does.
All right. And have you explained to him, I don't know how many prior theft by shoplifting convictions he has, if any.
The fourth will be a felony. He knows.
All right. Mr. Payne, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
Is anyone forcing you to take this plea offer today?
No, Your Honor.
And has it been explained to you that if you decide to enter this guilty plea, that you will not have a chance to go back to court and have a trial? You will not be able to confront your accuser, have the assistance of counsel, to challenge the evidence and witnesses brought before you, to be able to present any defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
And has Mr. McLean explained to you, to your satisfaction, that if there is a fourth arrest after 3 convictions for theft by shoplifting, the fourth arrest will be a felony matter?
Yes, Your Honor.
All right. How do you plead to 1 count of theft by shoplifting?
Guilty.
I'll accept your guilty plea. Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. If you have no other cases holding you at the Fulton County Jail, you should be released within 24 hours, and you must report to the probation office next Thursday at 132 Mitchell Street before 3 p.m. Once you report to probation, you will remain on probation to complete an anti-theft class, and you shall stay away from the Walmart store located at 970 Mansell Street in Roswell, Georgia. I can't remember whether it was street or road, but that's the only Walmart on Mansell, I believe. So stay away from that location. Mr. McLean, anything else?
Nothing else, Your Honor. Thank you.
All right, that concludes this case. Thank you.
Thank you.
That was number.
Position 24, Perry.
All right.
That was 23.
Ms. Allen, what's the announcement for Mr. Perry on the transfer? Oh, you're on mute, Ms. Allen?
The announcement is that a transfer is pending.
All right, so not a transfer yet. Mr. McLean, in light of a pending possible transfer to the DA's office, how are you proceeding today?
Well, Your Honor, it would be good to review the bond situation at this point, I believe.
All right,
I'm sorry, Your Honor. I think this is Ms. McLeod case.
Oh, is it? I'm sorry. If it is a conflict case, I should bow out.
all right.
And she's currently in Judge Richardson courtroom. She's gonna log on as soon as she's done.
Deputy Francois, position Mr. Perry will have to wait till his attorney logs in. Thank you.
You know,
Positions 25 and 26, samples.
Okay. Ms. Allen, while we're waiting for Ms. McLeod, is there a way you can reach out to anyone in your office to get a status of that transfer?
I'm working on it now. I'm also working on the add-ons and creating offers for the PDs in the courtroom.
Multitasking, my favorite
Yep.
kind. Thank
Yep,
you.
we got copies of the add-ons at 8:53 this morning, or at least I did.
Not a problem. All right. Mr. McLean, I'm so sorry. Who's seated next to you?
this is Mr. Samples, Your Honor,
Got it?
number 25 and 6.
Okay. And Mr. Samples has two cases before him. Good morning, Mr. Samples. My name is Judge Law. Your first case is State versus Alvin Samples, 17 CR 543, 9543Y, in which you have a traffic related matter in which the charges are speeding, failure to maintain lane, DUI, driving under the influence of alcohol less safe, and failure to exercise due care. The second case is a case arising from a bench warrant, 23 FTA 782. I understand that we are going to address a negotiated plea. You've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath? Mr. Samples, may I place you under oath?
Yes,
Thank you. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes, ma'am.
Thank you. Ms. Allen, what is the plea offer for Mr. Samples? Oh, unmute, please.
The
Thank you.
offer in this case, Your Honor, is 12 months to serve 28 days. Credit for time served, that's 14 days, and the balance probated. A $300 fine. What does RR mean, everyone?
Risk reduction.
Reduction.
Thank you. And ADET VIP.
Okay, so an alcohol and drug evaluation and any treatment that's required.
Thank you. And 40 hours community service.
And the VIP is one victim impact panel.
Thank
that-
you.
Would that be correct?
Yes, Your Honor.
Okay.
And I'm writing it down, what those mean.
Okay. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We
And-
certainly do.
Thank you, sir. And you've already discussed this with your client and he accepts these terms?
He does.
All right. Mr. Samples, have you consumed any medication or alcohol recently?
No, ma'am. Been 7 months,
Repeat, please.
been 7 months sober, ma'am.
Excellent. Thank you so much. I just needed to clarify one other matter before I resume my conversation with you. Miss Allen or Mr. McLean, can you confirm if we are addressing all 4 charges or any of the charges being null prossed or merged?
I cannot, but the state probably can.
We're not null prossing any of the charges on 17 CR 009543Y. We are, in fact, null prossing the failure to appear associated, and these are all concurrent.
Okay, thank you. So back to you, Mr. Samples. What I asked the attorneys was whether we are proceeding with a plea hearing in which you would be pleading guilty to all 4 charges, but the sentence that I would administer would apply to all 4. Is that your understanding?
Yes, ma'am.
Okay. And are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and voluntarily?
Yes, ma'am.
So no one is forcing you or inducing you to take this plea offer?
No, ma'am.
And has it been explained to you that if I accept your guilty plea to these charges, that you would have to waive your right to a trial, a right to go back to a courtroom with the assistance of counsel to confront your accuser, examine witnesses, challenge and contest the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of speeding, 1 count of failure to maintain lane, 1 count of DUI, driving under the influence of alcohol less safe, and the 4th charge of failure to exercise due care?
Guilty, ma'am.
Your sentence for all 4 charges going to be 12 months to serve 28 days, credit for time served 14 days. If there are no other charges holding you at the jail, you will be released within 24 hours. Next Thursday, today is the 7th, on September 14th, you will have to report to probation. That is located at 132 Mitchell Street in downtown Atlanta. You'll report to that office before 3 p.m. Once you are with probation, you will remain on probation to comply with the following conditions: to pay a $300 fine, complete a risk reduction course, see a qualified healthcare provider to complete an alcohol and drug evaluation, and submit yourself to any treatment that is recommended by the evaluator, and that must be done at your expense. You will attend and complete 1 victim impact panel as well. You will also complete 40 hours of voluntary community service, and that may be done at any nonprofit 501c agency, as long as it's not a school and not a church. So your options could be anywhere ranging from Goodwill to Salvation Army to animal rescue, food banks, and so forth, but not a church and not a school. You will remain on probation for the 12 months. You will refrain from consuming any alcohol, any alcoholic beverages, and you may be subject to random screens as well. Understood?
Yes, ma'am.
All right. Mr. McLean, is there an issue with the driver's license? This will be a suspension based on the DUI.
Your Honor, he's going to be in a program in Hall County with Judge Deal. And I think things will be, he'll have sufficient resources to deal with such matters at that point, and they can communicate with us. Your Honor, if there is a delay in his release, speaking of next Thursday at 3, if there's a delay in his release, I've instructed him to simply get over to JCS as soon as possible on a business day.
All right. They are open on Tuesday, Wednesdays, and Thursdays for new cases. So he can, if there's a delay, if he's not able to make it by next Thursday, it has to be any Tuesday, Wednesday, or Thursday after that.
Very good.
I've got 2 things I'd like to ask about now.
Are they questions for me, or do they have to be for the court?
I think it might be for the court about my license, because they was suspended back when it happened because I didn't blow in the machine. So they already suspended them for a year, and I had to pay and get them back. So this is like 5 years ago when all this happened. So I just didn't want them to be lost again.
Do you have a prior, does he have a prior DUI conviction?
20 years ago.
All right, this would not be, he would not be eligible for an affidavit of first conviction. He would need to go to the Department of Driver Services with a copy of this disposition, and the Department of Driver Services will let him know about his license status.
They were really good.
License suspensions is within the province of the Department of Driver Services. We just deal with the sentencing guidelines for a DUI.
You'll find out easy to get on.
What about this Thursday thing?
Oh, and I like to correct myself. Probation is on Monday, Tuesdays, and Thursdays, not Wednesday and not Friday. Thank you, Ms. Thomas.
You're welcome. Thank you.
Monday, Tuesday, and Thursday from, say, 9 to 3.
9 to 3, yeah. Monday, Tuesday, and Thursday.
So as soon as you get out, even if it's not going to let you get there by Thursday, the 14th of this month by 3 p.m., be there between 9 and 3 within a day or 2 or 3 of you getting out on any Monday, Tuesday, or Thursday.
All right, and the bench warrant case is null pros, so that concludes this matter. May we have the next case, please?
Good to meet you.
Positions 30 and 31, Salona.
I hope Mr. Dodis is getting a chance to speak to the other 4 cases that he needs to.
Your Honor, I've spoken with everyone in the room. I'm just waiting for someone to appear on the Zoom. I'm happy to do a breakout room when that happens.
Okay. 30 and 31, we have Danny Solano. And Mr. Solano also has 2 cases. The first one is 23 CR 0659A, in which she was accused of willful obstruction of a law enforcement officer and simple battery family violence from January 31st, 2023. The second case is arising from a bench warrant 23 FTA 781. Mr. Solano, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And I understand this is going to be a negotiated plea. Would that be correct?
It is. That is correct.
All right. Mr. Solano, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Allen, this is position 30. What's the state's offer on the two charges?
Your Honor, the state's offer is 12 months to serve, 36 days, credit for 18 days, balance probated, complete the FVIP training. No
Okay,
further contact with the victim, stay away from the location. I'll give you that address. (2825) Hemingway Lane. And the victim is Callan, Callan, first name, and Guerra, Guerra, last name.
Helen Guerra.
Yes,
Okay, and that
And,
was a family violence intervention program. And are you all still requiring the BHET, the behavioral
yes,
health? Okay, you are? Okay.
yes, thank you.
Mr. McLean, are those the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, those are the terms we discussed and the requirements, and we do so stipulate.
Thank you. Mr. Solano, have you consumed any medication or alcohol recently?
No, ma'am.
I'm sorry, I can't make out what you're saying. Could you repeat?
No, ma'am.
Thank you. And are you satisfied with your attorney?
Yes, ma'am.
All right. I'm going to ask you again, and with conviction, either say yes or no. Are you satisfied with your attorney?
Yes, ma'am. I ain't got no
Thank you.
choice.
He's sitting right next to you. I wanted to make sure. All right. And Mr. Solano, has anyone forced you, induced you to enter a guilty plea today?
Yes, ma'am.
Someone has forced you or induced you?
No.
All right. And are you entering this guilty plea freely, willingly, and knowingly?
Yes.
By knowingly, I mean that whether you understand that if I accept your plea, you will have to give up your constitutional right to a trial. You will not have a chance to go to court, have an attorney with you, to challenge the evidence and the witnesses brought against you, to confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Repeat.
Yes.
How do you plead to one count of willful obstruction of an officer and simple battery family violence?
Good.
Your sentence is going to be 12 months to serve 30 days. Was that 36 days? Yeah. To serve 36 days, credit for time served 18 days. So your jail time for this case is concluded. And if you have no other cases holding you at the jail, then you will be released and you must report to probation next Thursday before 3 p.m. at 132 Mitchell Street. While you are on probation, you will complete the Domestic or Family Violence Intervention Program. That's a 24-week program, and you must enroll in the program within 60 days of being released. You will report to probation every month, and you will make sure that you continue with those classes every time that you report to probation and let them know that. You will also go to a qualified healthcare provider to complete a BHET, that's a behavioral health evaluation. And if the evaluator indicates you need any kind of treatment or counseling, you must submit yourself to that kind of care. You are to stay 200 yards away from Callan Guerra. You are not to communicate with this person in any way, form, or manner, including a phone, computer, social media, or any kind of social media. I already said that, social media. You're also to stay away from 2825 Hemingway Lane in Atlanta, Georgia. Make sure that you maintain your current address with probation at all times as well. Do you have any questions about your sentence?
Well, I've been locked up 5 months. On this matter, I was just making sure I got credit for every time I done did it.
She stated it.
And I'll be released within 24 hours, right?
If you have no other holds, you should be released within 24 hours. And let me check on this.
Get immediate release, and I've been locked up 5 months.
Can I check on how long you've been with the Fulton County Jail?
Yes, sir. And I've been here 14 days, but I came from another facility and I've been over there like 5 months.
And why were you in the other facility?
Mhm.
Was it for another case?
It was for this right here. They were holding me for this.
Were you in the other facility for this case or for another case?
This.
I'm sorry, I didn't hear the response.
Never mind. I was just trying to get immediate release, man, because I've been locked up.
I just need to know whether I can credit you with 36 days or more. So if you're telling me it's been 5 months, that's,
Yeah, I've been locked up since June 1st.
again, Mr. McLean, perhaps you can enlighten us. Has he been detained on this particular case for
No.
up to 5 months, or am I attributing the correct amount of time for this case?
Your Honor, due to the pacing of our preparation for state all purpose, I have not obtained documentation from his prior facility of what charges were on his booking sheet there.
Okay,
I
So
can
he-
try- I can try to
he-
figure out the future.
okay, thank you, Mr. McLean. For this particular case, he was booked in on January 31st, 2023 at the Fulton County Jail, and he was released on February 4th, 2023. That's 5 days. And then he was arrested on the bench warrant and booked at the Fulton County Jail on August 25th, 2023. And then, and today would make it his 14th day. So he's been, he's been given credit for 18 days. So I will give him credit for 19 days. And we can amend that on the disposition. So, Mr. Solano, you have absolutely, you don't have to answer my question, but if you were booked into Fulton County Jail on August 25th of this year, and you were at another facility in another jurisdiction, I need to know why were you arrested and in that facility for almost 4.5 months before you were transported to Fulton County Jail.
Yes, sir.
All right. So are you exercising your right to remain silent on that?
Yes, sir.
Okay, good. All right, that concludes the sentence then. Thank you.
Thank you, Your Honor.
Add-on position number 4, Mr. Rhodes.
And that would be at location 4 North. Would that be correct, Deputy?
And
Yes, ma'am.
Thank you.
Your Honor, last I checked, we didn't have an offer for the add-on calendar. We'll need a breakout room once we have that.
All right, Mr. Dotis, do you have your handy dandy laptop open?
I do. Again, Your Honor, we need an offer from the state, is my understanding. Do we have one?
I'm sorry, Mr. Dotis, could you come closer to the
Your Honor,
it sounds, I know you all have to wear masks, but it's very muffled.
Your Honor, Mr. Rhodes is on the add-on calendar. My understanding is we're still waiting for offers for all 4 positions on the add-on calendar.
Miss Allen may have sent it by now.
I just sent you an offer on number 4, and I'm working on number 2 and 3 right now, as well as number 1.
Thank you. Did you send that to my email, Miss Allen?
I did.
Okay.
All right. Deputy at 4 North, unfortunately, I cannot address any of the add-on cases until Defense Counsel Doties has had a chance to speak to all 4.
Right.
Do you have Christopher Adams, Dale Allman, and Edward Rhodes all at 4 North?
This is Edward Rhodes, and I
Right.
have Mr. Gresham and Demario Dawson.
Okay,
Those are the people that I have out right now.
okay, Mr. Rhodes, Mr. Doties is going to have to speak to you on a breakout. But so we're going to wait for Mr. Doties. Okay, he's already logged in.
This should be quick, Your Honor. I did meet with Mr. Rose yesterday. I just didn't have an offer, but I'll be
do it right here.
in a breakout room.
Okay. Mr. Jordan, if you could please place PD Angelo Doties and 4 North in a breakout. And then Deputy, as soon as we're done with Mr. Rhodes, I can take the next case. Did you say Gresham?
Yes, ma'am.
Okay, all right, thank you. Mr. Doties, you should be in a breakout.
Yes,
Okay.
Your Honor. I'm headed out. Thank you.
Gresham is 12, that's the other, there's somebody, I don't know who it is.
I'm gonna do correct.
If you said Gresham, that's in his territory, but if it's not our place, we need to speak to somebody else.
All right, Deputy Francois, I can take another case at courtroom 2.
Yeah, it's gonna be position number 32. Mr. Stephen, have a seat over here for me. Scoot the chair back, behind you.
Actually, 32 is 9. 32 is 9. You know, the situation with 32 is, that is position number 9.
And that's Mr. Doty's case?
Right, because 32 is simply the FTA portion of his doublet.
Understood. Thank you. Can I have position 33 if Mr. Sutton is in the courtroom?
Okay, so that's Doty's case.
Yes.
Yes.
Go back and have a seat.
And I think, I'm not sure how it was the wording of the transmission of the announcements we made, but I saw a 365 in the offer on Sutton. And because of certain time credit, if the state intended that to be time served, that's a plea. Otherwise, we need to reset that and talk further next week.
And about whom are you discussing?
Sutton.
Well, if Mr. Sutton will come forward, please. I think he's on the second row. And Miss Allen, could you clarify the sentence for position 33 on Michael Sutton?
Yes, Your Honor. So
I have
The,
12 months to serve 15 days. Is he being given credit for 15 days or 7 days? What are we talking about?
time served would indicate that he is not required to serve any more time. So
That would
in
be-
exchange for a guilty plea, it looks like we think he has served 15 days, but we can adjust that date or number of days based on a different calculation if that's appropriate.
Let me see. All right. Mr. McLean, your client, Michael Sutton, is accused of criminal trespass in case number 22 CR 5933H, and the incident was from October 31st, 2021. Okay, Halloween, about 2 years ago. All right. And he was in custody at that time for 3 days. And then he had a bench warrant in which he was then booked back into the Fulton County Jail on August 23rd. And he's been in custody for 16 days. He's been in custody now for 19 days. So if the state is offering him a time served, it would be 12
19
months.
days now.
Okay, so it'll be 12 months to serve 38 days, credit for time served 19 days, balance suspended.
Right, I may have had a misreading of some numbers, and he understands the sentence proposed and would like to make this a negotiated plea, Your Honor.
Okay.
Stipulating all necessary elements and asking the court to accept his plea as voluntary.
And have you completed the plea sheet or do you have authority to do so by your client, Mr. McLean?
Your Honor, we went over what's called, we call it a colloquy if it's oral, and we call it a plea sheet if it's written, and we went over all the questions orally yesterday.
All right, thank you. Mr. Sutton, you've been advised of your right to remain silent, and your attorney is Mr. McLean. As indicated, you have one case for the criminal trespass, and you have the second case, 23 FTA 777, arising from the bench warrant. For purposes of this plea, may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. So Ms. Allen, I may comfortably say then it's 12 months to serve 38 days, credit for time served 19 days, balance suspended. Would that be?
Yes, Your Honor.
correct? Thank you. Mr. McLean, do you stipulate to the factual basis, venue and ID?
We do, Your Honor. It's the one count of trespass. That's correct.
Thank you. Mr. Sutton, have you consumed any medication or alcohol recently?
I have not.
Repeat.
I have not.
And have you understood the proceedings so far?
I do.
And has anyone, I'm sorry, I forgot to ask the important question. Are you satisfied with your attorney?
I am.
And has anyone forced you or induced you to take this plea offer today?
No, ma'am.
There was a lot of discussion about how much time you've been at the jail. Do you have any questions about the plea offer that's been made to you today?
No, ma'am.
Okay. And if you decide to plead guilty to this criminal trespass charge, you would have to give up your right to go back to court and have a trial. You would not be able to confront your accuser, challenge the evidence brought against you, examine witnesses, present any defenses you may choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 38 days, credit for time served 19 days, balance suspended. If you have no other cases holding you at the jail, you should be released within 24 hours. Thank you. Oh, and the bench warrant matter on position 34 is null pros.
Have a blessed day. Thank you. Good to meet
Thank you, sir.
Are we ready for position add-on number 4, Mr. Rhodes?
Yes, Your Honor, that'll be a negotiated plea.
Okay.
Hey, good morning, Jay. Yeah, hold on one second.
Okay, this is State versus Edward Rhodes, who is located at 4 North at the Fulton County Jail. Mr. Rhodes' case is 23 CR 5155J. In that particular case, Mr. Rhodes is accused of theft by taking stemming from an August 22nd, 2023 incident. And Mr. Rhodes, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Angelo Dotis is your counsel. This is going to be a negotiated plea hearing. So in that event, Mr. Rhodes, please, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Allen, what is the plea offer for Mr. Rhodes?
Your Honor, the plea offer in this case is a 12-month probation, serve 30 days, credit for time served, and to stay away from the incident location, which I'll give you in just a second. It is a convenience store. One moment, let me pull it up.
Mr. Dotis, while we're waiting for that information, is the BP gas station at 720 Donnelly Hollowell? Would that be correct?
Yes, Your Honor, that's what I have for the address.
Okay, Ms. Allen, would that be correct?
Yes, Your Honor.
Okay, and I noticed that, I just want to make sure about a couple of things. I see 2 other companion cases. Okay, that has been disposed of.
He's not in a court.
Your Honor, my understanding was that this was the only case holding him. I'm not sure if he has any other open cases.
Just checking.
Thank you.
And yeah, they were both disposed of, so we can proceed with this one. And Mr. Dotis, does your client accept the terms of the plea offer?
He does, Your Honor, and he is clear this is a time served offer. He has credit for 17 days, which I've indicated on the plea sheet. So he does have enough for the 30 days the state is asking for. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Thank you. All right, Mr. Rhodes, if Deputy could, thank you. Have you consumed any medication or alcohol, sir?
No.
And have you understood the proceedings?
Yes.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you to take this plea offer today?
No.
And has it been explained to you that if you decide to plead guilty to this charge, that you would be giving up your constitutional right to a trial, to confront your accuser, have the chance to go back to court with your attorney to challenge the evidence and witnesses brought before you, and have the state try to prove the charge against you beyond a reasonable doubt?
Yes.
So you are prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass? Oh, excuse me, theft by taking.
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 17 days, so you have more than satisfied the jail time. You are, as far as I can tell, the other cases have also been resolved, so not sure if you're supposed to report to probation on these other cases, but in this particular case today, you will, the jail time is over. You don't have to report anywhere. The case is concluded. You just cannot return to the BP gas station at 720 Donnelly Hollowell Parkway.
Yes,
If
ma'am.
you go back to the gas station, to the sidewalk, to the parking lot, all they have to do is call the cops and you're back in jail. Okay?
Okay.
All right. Thank you.
Good morning, Your Honor. This is ACDC.
Yes.
We have position 5, Regina Curry, and after her is position 17, Shante Jackson.
Mr. Dotis, are you ready to move forward with 5 and 17?
Yes, Your Honor. Position 5 is also position 4.
That's correct, Your Honor. It's
All right.
just a misspelling on the calendar.
No problem. Position 5 is also position 4. Okay, and position 17. Okay. All right. So who is seated right now, please?
Position 5, Ms. Curry.
Okay. This is State versus Regina Curry. Ms. Curry, you have 2 positions on our calendar today. Were you aware that we are addressing 2 cases with you? You need to speak up.
Yes, Your Honor.
Thank you. Position number 4, Ms. Curry's case number is 23 CR 1143G, in which she's charged with criminal trespass from a February 27, 2023 incident. With regards to the second case, 23 CR 5017G, Ms. Curry is accused of criminal trespass and PI from an August 16, 2023 incident. In both cases, Ms. Curry, you have a right to remain silent. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and representing you in both cases is Mr. Angelo Dotis. And what are we doing for position 4 and 5? Are they both negotiated, please?
Your Honor, they may be negotiated. Position 4, I did want to confirm jail time. I believe Mr. Pellon did email me back, but I can't remember if the jail time that he's asking for position 4 was actually the time she got for position 5. If it's a time served offer, that'll be negotiated for the criminal trespass charge. If not, we proceed non-negotiated. And position 5 would be a no-low request.
Your Honor.
Yes, sir.
Position 4 is a time served. That was, Mr. Dotis is correct. That was my error in calculating. The defendant has spent 3 days on position 4, but she spent 22 days on position 5. So we were intending a time served on both.
So what would it be? Serve 50 days, credit for time served 25 days?
It would probably be more proper, Your Honor, to say for position 4, 12 months, serve 6 days, credit for time served 3 days. And then on position 5, 12 months to serve 44 days, credit for time served 22. I think that's what's most appropriate. Mr. Dotis can correct me if he disagrees.
I agree with that completely, if that works for you, Your Honor.
Okay. And stay away from all model locations in accordance with the suspension. Does she have an active suspension?
I'd have to double check that, Your Honor. She did have an active suspension at the time of both separate offenses. I believe at this point she has a permanent suspension, but I wouldn't rely on my memory.
I've got continuous model-related arrests from 2021, 2022, and 2023 were three separate cases or three separate arrests. So, Mr. Doties, do you know if your client has a permanent bar to all model services?
Your Honor, I have not been able to look into that with the limited time for this calendar. I would just ask if we were to just comply with any and all active MARTA suspensions. If she does have a permanent ban, then that would still be a stay away.
And the
All right.
state doesn't object to that wording.
All right, in that event, then I will deem this to be a negotiated plea. Ms. Curry, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Curry, before I begin with the hearing, do you understand that with regards to both these cases, if you decide to move forward, you will be entering a guilty plea to two separate cases, which will add more convictions on your record? And you will also be required to stay away from all MARTA trains, all MARTA buses, all MARTA stations for as long as there's a suspension against you. And right now, I don't know when your suspension ends, whether it's going to end in a few months or whether it is a permanent suspension. Do you still want to move forward with this plea?
Yes.
Mr. Dotis, shall we move forward?
Yes, Your Honor, I did speak with Ms. Curry. She is aware of the situation. I've also instructed jail staff to provide her with a resource sheet that includes a number to reach out to MARTA to verify any active suspension. So she knows what's required of her. Again, we will also be requesting to enter a plea of nolo on position 5.
On both counts or which one?
On count 2, Your Honor.
All right. Any objection, Mr. Pellon, with regards to a nolo to the PI charge?
I'd request Ms. Allen to weigh in. I'm not sure my office's particular position on this. Ms. Allen, she, the defendant, is seeking to enter a plea of nolo to a PI charge.
That's not a problem.
Okay, I didn't think so. So no objection from the state, Your Honor.
All right. So this is then a negotiated plea. Mr. Pellon, so you've indicated that for position 4 is going to be 12 months to serve
6 days, Your Honor.
6 days, credit for time served 3 days, and to stay away from all MARTA locations in accordance with any active suspension. Would that be correct?
Yes, if that satisfies PD's request, which I think it does,
I think
to comply with all active MARTA suspensions.
that's fine, Your Honor.
Sure.
Thank you.
And with regards to position number 5, it's a guilty plea to criminal trespass and a no contest to the PI charge in exchange for a proposed offer of 12 months to serve 44 days, credit for time served 22 days. And again, you've got a requirement for probation and SD. Well, why don't you tell me the offer then for position 5?
Yes, Your Honor, I believe you have it. It's 12 months to serve, 44 days, credit for time served 22 days, balance probated, SDET, and to comply with all active MARTA suspensions.
All right. Mr. Doties, these are the two plea offers for positions 4 and 5 respectively. Is that what your client has agreed to?
Yes, Your Honor, we did discuss that, and she is clear on what is required of her and where to go for the SDET.
And do you stipulate to the factual basis, venue, and ID for both cases?
We do so stipulate to the three elements for both cases.
Thank you. Ms. Curry, I'm going to address each case one by one with you, okay? The first one, position number 4, is a criminal trespass charge from February 27, 2023, February of this year. Do you recall that case?
Yes, I do.
All right. First of all, have you consumed any medication or alcohol?
No, Your Honor.
And have you understood your attorney in his explanations to you?
Yes,
Are you satisfied with his services?
yes.
And Ms. Curry, is anyone forcing you to enter a guilty or no contest plea today?
No.
And if you decide to enter such a plea, you would be giving up your rights to have a trial, giving up a right to have an attorney help you during the course of a trial, where you get a chance to confront your accuser, challenge the evidence brought against you, examine witnesses, present any defenses you may have, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you willing to give up these rights?
Yes, Your Honor.
Repeat.
Yes, Your Honor.
Are you doing so freely, willingly, and knowingly?
Freely.
I'm going to ask you again. Are you giving up these rights freely, willingly, and knowingly?
Yes, Your Honor. Do you want me to be specific or what?
I just want, you don't sound very sure. And
Yes, I'm very sure, Your Honor. I don't need to be here.
I'm asking this right because I'm looking straight at
Yes.
you on my huge laptop screen, and you don't you don't look very certain.
I'm very certain.
Okay,
Yes.
because one thing you should understand is that even though your attorney and the prosecutor may agree to these terms, I still get the chance to say no to this deal if I have any question that you're not entering a plea freely, willingly, and understanding the rights that you're giving up.
I understand.
Okay. How do you plead to one count of criminal trespass from February 27, 2023?
I guess, no would be my answer.
See, now you look uncertain again.
And Your Honor, if maybe it would be best if I speak with Ms. Curry on the phone to make sure that we're clear.
I'm clear, baby. I'm just trying to get this over with. I may have been there, but like I wasn't just like on that property, practically what I'm saying, but no love.
Okay, then just based on that response, Ms. Curry, I think you need to speak to your attorney so that he can explain to you what I'm looking for. And your attorney's name is Angelo or Mr. Doties. His name is not Baby. Understood?
Oh, okay.
Thank you. Next case. Position number 19.
Position 17, Ms. Shante Jackson.
17. Thank you very much. This is State versus Shante Jackson. Ms. Jackson was accused of battery, theft by shoplifting, and disorderly conduct in case number 23 CR 005205C. This is stemming from an incident of August 24th, 2023. Ms. Jackson, you have a right to remain silent about the facts of the case. Any statements you make, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Angelo Doties. This is a negotiated plea hearing, so position 17, yeah. Ms. Jackson, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Is it Mr. Pellon or Miss Allen?
It's me, Your Honor.
All right. And Miss McLeod, what was your client's name? I'm sorry.
Judge Laws, we can do
No, I just want to make sure we have Miss McLeod on.
client next. That's
Yeah,
gonna be
she
position
will do
number
a client
24.
next. Yeah, thank you so much. All right, Mr. Pellon,
Morning, Your Honor.
good morning.
My client is on position 24. I understand this case is pending transfer to the DA's office.
Correct, yeah, and I don't have any announcement today, so what would you like to do?
I just logged on, Your Honor, just to make that announcement that I understand nothing is going to happen to his case because it's going to be transferred up to the DA's office.
Okay, I'll give it a 1-week reset and if it's not transferred, then y'all can consider your other options next Thursday.
Yes, Your Honor, thank you.
Thank
May
you.
I be excused?
Yes, thank you, Ms. McLeod.
You're welcome.
Deputy Francois, Ms. McLeod's client's case is going to be reset 1 week. And then if the state has no transfer, then we can either consider a plea or an arraignment.
Okay, sounds good.
Thank you.
Thank you.
Thank you, Ms. McLeod. All right, Mr. Pellon, sorry about that. What is Ms. Jackson's plea offer?
Your Honor, state's recommendation in position 17 for Ms. Jackson is 12 months to serve 30 days. Credit for time served 14 days, balance probated, an 8-week anger management course, a $500 fine, anti-theft course, no further contact with the victim, Mr. Rajman Singh, and a stay away from 5110 Old National Highway, College Park.
All right,
That's a Chevron gas station, Your Honor.
all right, thank you. Mr. Jackson, excuse me, not Mr. Jackson, Mr. Doties, yes, sir. Are those the terms to which your client has agreed, and do you stipulate to the factual basis, venue and ID?
Your Honor, we would ask it to be worded as serve 28 days credit for 14 days. I don't see any reason for 1 extra day of jail time. We would also request that the fine be converted into community service hours, as Ms. Jackson is not currently employed and understands she will need to pay for the classes.
State doesn't object to either of defense's request, Your Honor.
It's so it'll be 28 days, serve 28 days, credit for time served 14 days. And Mr. Doties, I'm so sorry, I didn't hear the terms of the second request. To what now? To terminate or a non-reporting?
Your Honor, we asked that there's a fine that the state was asking for. We just asked that and they agreed to have that convert to community service hours.
Yeah, 50 hours of community service. Would that be satisfactory?
That's my understanding of the conversion. That would be satisfactory for us. That's what I communicated to my client. We would also, as Your Honor mentioned, ask if she could switch to non-reporting status and waive a few months of her probation fees to allow her to complete these conditions and get back on her feet.
All right. Any objection to non-reporting?
That's only non-reporting after the terms are completed, Your Honor?
Correct. She would have to complete the 8 weeks of anger management, complete the community service, complete the class, and then she will be non-reporting. But she's still required to stay away from the Chevron and have no contact with Mr. Singh.
Correct, Your Honor. Yes, state doesn't have an objection to that.
All right. And I'll waive probation fees for the months of September and October.
Thank you, Your Honor.
Okay. So do you stipulate to the factual basis, venue and ID, Mr. Dotis?
Yes, for the purpose of the plea, Your Honor.
Ms. Jackson, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am, I have.
Are you satisfied with your attorney?
Very.
And are you, is anyone forcing you or inducing you to enter a plea today?
No, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial. You will not have the assistance of counsel to go back to court, to challenge the evidence brought against you, examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to do so?
Yes, I am.
How do you plead to 1 count of battery, 1 count of theft by shoplifting, and 1 count of disorderly conduct?
Guilty.
Your sentence is going to be concurrent for all 3 charges, and that is 12 months to serve 28 days, credit for time served, 14 days. You'll be released within 24 hours. You must report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. Please report to the probation office next Thursday before 3 p.m. You'll be
Thank you
placed. You're welcome. You'll be placed on probation. Your probation fees for the months of September and October are waived, but you must start paying probation fees from November 1st, 2023 onwards. While you're on probation, you will complete an 8-week anger management program. You will complete 50 hours of voluntary community service at any nonprofit agency, which is not a school and not a church. You will also undertake an anti-theft course. At all times, you're to have no contact with Rajman Singh. I assume he is an employee at the Chevron gas station. And you are to stay away from that gas station located at 3110 Old National Highway in College Park. After you've completed the anger management classes, the community service, and the anti-theft class, your probation may be non-reporting. What that means is that you don't have to report to probation after that, and you won't have to pay probation fees. So the sooner you're done with the conditions, the sooner that would happen. Understood?
Thank you. Understood.
And even whether you are on non-reporting probation or active probation, you're still required to have no contact with Mr. Singh and stay away from the Chevron.
I don't want to go there ever again.
Sounds like a plan. Thank you.
Your Honor, if I may clarify while defendant is still there, the proper address is 5110.
Did I say 3? I'm so sorry. Okay. 5110. Well,
Yes,
she has
Your
no
Honor.
plans to go back. So that sounds good. Thank you. Mr. Dotis, thank you. We are still, Deputy Milton, we still have Miss Curry to deal with. So Mr. Dotis wants to talk to her. Meantime, I have 4 North and 5 South that I'm going to go to.
Your Honor, can Mr. Dotis, is he gonna call ACDC now?
Hang on, just give me 1 second. 5 South, who do we have in 5 South?
I'm sorry, excuse me.
Yeah, Mr. Pharrell from 7 North. Position number-
Hey, I got a quick announcement.
Okay.
For Mr. Harry Brown, he was supposed to be on 2 South, Will, but he got moved to 5 North 308.
What does that mean?
You said who?
Mr. Harry Joe Brown, he was on 2 South 116, he got moved to 5 North 308.
Okay, I'll give him. And I think Mr. Almondale is on 2 South.
Mr. who?
Mr. Almondale Robin, I think he's on 2 South. He's at the bottom of the list. It said on here he's on 7 South 500.
All right, just let Ms. Blunt know.
Okay.
Mr.
Deputy at 5 South, who do you have seated next to you?
Mr. Fair, hold on, give me 1 second.
Thank you. 4 North, who is seated at 4 North?
This is Dawson,
Repeat the last name?
number 8.
Number 8.
Dawson.
That's Mr. Doris Klein. Okay, please hold for.
No, Dawson, Mario Dawson.
Got it.
Your Honor, I did meet with Mr. Dawson, but that was before I learned he's a conflict. I reached out to Attorney McLeod. She also represents another co-defendant. So Mr. Dawson will need a C3 attorney. I will note that this case is not holding him if it needs to be reset for the court to find the C3.
Understood. Thank you very much. Okay, back to Mr. Dawson, please hold. 5 South, who is seated next to you?
I have positions number 10 and 11.
Okay, that's Mr. Dotis as well. Thank you.
Okay, I also with me have position number 37.
Can I take position 37 first, please?
Okay, wait.
All right, and Mr. Dotis, please contact ACDC to speak to Ms. Curry.
And then after that, I have position number 27 and 28.
Okay, they're all Mr. McLean's, so we're gonna do these cases first, and then after that, we'll get back to Mr. Dodis's client. Mr. McLean, you ready to go with 5 South?
Your Honor, I need the ACDC phone number. Milton is there to put it in the chat if you all know it.
Deputy Milton?
If you want to call Corbin too.
All right, as soon as she's available, she's off screen and there's no one at ACDC, so hopefully they're reaching out to you. Mr. McLean, we're going to address the cases at 5 South for you. And so let's get ready. Just as a briefly, 4 North, Mr. Dawson. This is State versus Mario Dawson, charged with a FRAVE in 23 CR 5061G. All right, 4 North, could you unmute, please? All right, Mr. Dawson, you have a right to remain silent about the facts of the case. Any statements you make, it will be used against you in the treatment of your case. You have a right to an attorney. So that's the one I want to talk about. Right now, you are not represented by counsel. You were improperly assigned to the Public Defender's Office and then to Ms. Maureen McLeod. Those individuals cannot be your attorney. Your attorney has to be appointed separately. So, Mr. Michael Jordan, we need to appoint a C3 counsel. And quite frankly, I can't think of a single name off the top of my head right now. Mr. Jordan?
Yes, sir.
We need a C3 counsel for Mr. Mario Dawson, position number 8.
Why are they doing this?
Okay. Mr. Dawson? Mr. Dawson? Mario Dawson? Please, do you want to ask the officer or would you like to ask the court?
I would like to ask the court.
Okay, there are co-defendants in your cases. There are other individuals. Co-defendants.
Okay.
The public defense has already got one of them. The conflict counsel has already got another one. So that blocks them out from representing you. I need to have a totally different class of defense attorneys to appoint to represent you. And they are called C3, conflict 3. All right? Because you cannot be represented by the same attorneys who represent the other defendants. Do you understand, sir?
Yes.
And I'm going to reset your case 1 week for a C3 attorney to be appointed and to reach out to you. Understood? This case that is the Affray case that is currently pending against you. Is that the case you're here for today?
Yes.
That case is not holding you at the jail. You have other cases holding you at the jail.
All right. Do I have a court date on on the other case that I have?
Let me see. I don't see one right now.
All right.
Thank you.
All right.
5 South. Ken, could you repeat the name of the individual seated next to you?
Mr. Wiggins, position number 37.
All right, thank you.
That's perfect, Your Honor. I was just about to interject. We put in TBA to be announced for Mr. Wiggins. The only appropriate announcement for Mr. Wiggins today is to ask for a 1-week reset.
The reason?
I need to confer with this felony attorney. He was not available for interview yesterday when I was here for a 12-hour period.
Okay. Let me get to the right page. Oh my goodness. Okay. This is State versus Del Monte Wiggins. Are you Mr. Wiggins? I can't hear, Deputy.
Yes, ma'am.
Mr. Wiggins, you're accused of simple battery and PI from a August 14, 2023 incident in case number 234992F. Your appointed counsel is Mr. Michael McLean. Mr. McLean will need to confer with your attorney in your other open case. So this case is going to be reset for 1 week to September 14th. And by then, Mr. McLean will be able to advise you accordingly. Thank you.
No, she said, so you said he's an attorney in my other case too?
You have another attorney in your other case.
Yeah, Honoragis.
Who?
Mr. Ragis, Honoragis.
Okay, so Mr. McLean is your attorney in this misdemeanor case. And those two need to talk so that Mr. McLean can advise you accordingly.
I already know what was going on with this one. The lady-
Your Honor, if I may, Your Honor, if I may, Mr. Wiggins, you know what's going on. You and I will know what's going on if I'm going to represent you. The two of us will know what's going on, not just you. So I'm going to reset your case for a week. There's no harm to your freedom. Thank you.
All right, see you next week. Thank you. Next position, 5 South.
Judge Law, can we do some of our cases here in courtroom 2?
Let me just find out who's at 5 South, but that's Mr. McLean's case next, and Mr. Doty still needs to talk to Ms. Curry.
Your Honor, I did speak with Ms. Curry. The ACDC did call me on the phone. We're prepared to go forward with the plea. I believe we've straightened everything out.
Okay, good. 5 South, who do you have next?
Smith Random, position number 27 and 28.
27 and 28, and that's going to be a negotiated plea. Is that correct, Mr. McLean?
Yes, Your Honor, that's Mr. Smith has 2 cases.
Okay.
And although they're next to each other, one is not an FDA.
Lots of pages. Okay. This is State versus Brandon Smith, 20 CR 001-687E, in which he was accused of battery. And Brandon Smith in position 28, case number 21 CR 043E, in which he was accused of simple battery. The first case stems from a February 2020 incident. The second case stems from an April 2019 incident. Mr. Smith, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Michael McLean. This is going to be a negotiated plea hearing. Deputy, could you please unmute 5 South so I place Mr. Smith on? Please raise your right hand, Mr. Smith.
I'm about to go get.
Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
It will.
Thank you. You may mute 5 South. Ms. Allen, what are the plea terms for position 27?
Thank you, Your Honor. For position number 27 and 28, identical terms and concurrent, 12 months probation to serve 36 days, credit for time served. The number we have is 18 days, but that may need to be modified based on a day or two, I believe. Balance probated, 12-week anger management course, and no further contact with the victim. Miss Bianca Porter, last name Porter, first name Bianca.
Thank you. Mr. McLean?
Your Honor, we have discussed the various resources available for him to find, to obtain a qualified anger management company or individual. And he asked the court to accept his negotiated plea of guilty as he stipulates to the necessary elements on both cases.
Is he willing to start the anger management classes within 60 days of being released?
That should not be a problem, Your Honor. It's a very reasonable time frame to start that.
All right, as long as he understands that. Let me see, I have 20 days in custody.
That'll certainly take care of the time that the state is asking for. Let's see if I may lean over here.
Well, it's 18 days on 18 days on the battery charge and 2 days on the, no, it's 18 days on the simple battery. 18 days on the battery charge and 20 days on the simple battery.
Right, as
That's
long,
what I've got.
right. He's got the requisite number of days to turn this into the jail portion of the sentence will be over, and then he'll start his probation as soon as he's released.
All right, and will he be released within 24 hours, or does he have any other matters holding him?
I would have to consult another sheet, Your Honor, if he does have any other matters holding him.
I have a July 2019 incident. And that looks like a Superior Court matter.
Right, if that's in Superior Court, I will shoot an email to the appropriate felony attorney in our office, assuming that we may represent him on that and let him know that he's free to deal with that one.
All right, Mr. Deputy, if you could unmute 5 South, please.
Yes, ma'am.
And Mr. McLean, we're going to enter the necessary stipulations, right?
Yes, Your Honor, we do.
Okay. Mr. Smith, as far as you know, these are the 2 misdemeanor cases against you. Are you aware that you may have another case in Superior Court of Fulton County?
No, I'm not.
It's from a 2019 incident for battery and false imprisonment.
Never did happen. 2019. When did this happen? Where? When? How?
Your Honor, I would be glad to communicate with the felony division of our office. And if he's got anything in Superior Court, they'll take care of it.
Okay, nope, hang on. It looks like it's a closed case. It was 19 SC 169740.
Does it appear to be closed, Your Honor?
I'm checking. It was before Judge Ellaby. The alleged incident date was July 8th, 2019.
What are they doing?
Mr. Smith, I'm just going to, and it looks like you pled guilty to the battery charge on January 31st, 2020.
It's a lot of Brandon Smiths. I'm Brandon Liddell Smith.
Yeah, I'm going to check and see.
Steve Smith.
Hang on. Yep, I'm looking at your mugshot on for that case.
Yeah, all cases that I know of right now
It's you.
spoke to me.
It's you.
Yeah, okay. All cases that I know of were spoke to me by Mr. McLean yesterday. Did I know that I have this current, ma'am?
Whatever.
Yes, ma'am.
Mr. McLean, I'm ready to proceed with the plea. You are?
Yes, we are, Your Honor. Thank you.
Okay. Mr. Smith, have you consumed any medication or alcohol recently?
No, I haven't, ma'am.
And have you understood what's been going on so far with regards to the 2 misdemeanor cases before you?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, I am, of course.
And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am, they're not.
All right. And has it been explained to you that if you decide to plead guilty to these charges, that you would have to give up your right to go back to court, to have a trial in both cases, to be able to confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt?
Yes, ma'am, I am.
And you're willing to give up these rights?
I am, yes, ma'am.
How do you plead to 1 count of battery stemming from a February 18th, 2020 incident?
I plead guilty.
You sounded.
No, no, guilty. No, I thought we already had went over there. I went past that
No,
stage.
I'm done with the felony case against you. I'm talking about the misdemeanor case. How do you plead to 1 count of battery from February 18th, 2020?
Guilty, ma'am.
How do you plead to 1 count of simple battery from a April 5th, 2019 incident?
Guilty, ma'am.
Your sentence is going to be for both cases. It's going to be for 12 months to serve 20 days, credit for times, to serve 36 days, credit for time served 20 days. So your jail time for both cases is over. While you'll be completing the rest of the sentence on probation. You have to report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. And next Thursday is the 14th, and you must report before 3 p.m. While you are on probation, you need to complete 12 weeks of anger management classes. You must begin those classes within 60 days of being released. If you fail to enroll in those classes within 60 days, probation has the right to have your probation revoked, and you complete the rest of the time in prison. At all times, you are to have no contact with Bianca Porter.
How long am I supposed to be on probation?
For 11 months and 10 days.
Okay, all right, it's not completed after the classes? After the
No,
classes?
you will report to probation every month.
Yes, ma'am. Okay,
And more importantly, you're to start your classes within 60 days, and you're to stay away from Bianca Porter and not communicate with her in any way, form, or manner.
yes, I think she's back in Texas, but yes, ma'am, I will.
All right, thank you.
Hey, ma'am, what does this mean? So what does this leave me for today? Is it
This
being
means that you are convicted of both these cases today. They will go on your criminal history record, and you will be processed and released within 24 hours if you have no other cases holding you. And then you got to make a date with probation next Thursday before 3 p.m.
Yes, ma'am. All right,
Anything
thank
else?
you. No, ma'am, thank you for your help.
You too. Ms. Curry at the ACDC location. We're going to resume with her plea. Mr. Dotis?
Yes, Your Honor, we do stipulate the factual basis, venue and ID, and we just ask for the plea to be accepted as negotiated. Ms. Curry is clear on the terms and what's required of her.
All right. I'm going to start with 23 CR 143G, in which she was accused with criminal trespass from February 27, 2023. Ms. Curry, we've already gone through quite a few of those questions. I'm going to ask you again where we last left off. How do you plead to one count of criminal trespass from February 27th of this year? Repeat.
Guilty.
Thank you. Your sentence will be 12 months to serve 6 days, credit for time served 3 days, balance suspended. You have to stay away from all model locations in accordance with any active suspension. How do you plead to one count of criminal trespass and one charge of PI in case number 23 CR 5017G, stemming from an August 16th, 2023 incident? You have two charges here, criminal trespass and PI. How do you plead to criminal trespass?
Guilty.
How do you plead to PI?
Guilty, I guess. I won't say no longer. Guilty.
Mr. Dotis?
Miss, I think she's confused by the abbreviation, Your Honor. This is the.
I understand what I'm saying.
PI stands for public indecency. How were you planning to plead to that charge?
Oh, no, baby, because I only had on shorts. I don't know what public is.
All right. I'll accept your guilty plea to criminal trespass and your nolo contendere plea to the PI charge. Your sentence is going to be 12 months to serve 44 days, credit for time served 22 days, balance suspended. You are to stay away from all model properties, buses and stations and trains, and in accordance with any active suspension. Your attorney should have given you information on how to reach the MARTA headquarters to check and see whether you have any suspensions and when will they end. It is a possibility that you may have a permanent suspension against you, which means that you cannot go to any MARTA property ever.
Okay.
Your
Thank
Honor,
you.
I just wanted to clarify with the court that the state's recommendation in The second case, position 5, was balance probated and included in SDET.
Oh, you're correct. I'm so sorry. I was reading off my notes for the first case. Sorry about that. Ms. Curry, I'm going to have to revise your disposition for the second case involving the public indecency. Is 12 months to serve 44 days, credit for time served 22 days, is balance probated, in which you will have to do an SDET. Has your attorney explained to you what an SDET is?
No, ma'am.
And Your Honor, I think it's, again, I did meet with Ms. Curry. If we need to speak further, I'm happy to. We did go over what that meant. I think we're getting confused by the abbreviation, but this is what I was talking about, going to Brady to seek treatments. Your probation officer can provide you with more details on making an appointment, and Officer Milton should have a resource sheet to give you with all numbers and locations.
Ms. Curry, your attorney never explained to you that you had to go to Grady for some kind of
I don't know, the abbreviation of, he explained that.
Okay, so you understand you have to go through some kind of mental health evaluation or behavioral evaluation?
Yes.
Okay, so, and I'm sorry, I'm getting confused because I've got so many notes and we keep going back and forth with your case. So I want to make sure that at least that you understand, and I don't want you to, have any problems just because I'm confused.
Yes, ma'am.
All right. So on the first case for criminal trespass, you're done with jail time. You just have to stay away from martyr property. Understood?
Yes, ma'am.
In the second case with the criminal trespass and the public indecency, you'll be on probation once you're released from jail.
Okay.
You will need to report to the probation office next Thursday.
Okay.
Your report date is next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta.
Okay.
If you don't report, they will revoke your probation and you spend the rest of the 12 months in jail.
Okay.
While you're on probation, you will do this program at Grady and you will report to probation the status of your evaluation. Understood?
Okay.
And you are to stay away from all martyr property in accordance with any suspension.
Okay.
Mr. Dotis, any other?
Yes, Your Honor, we would ask if this court could waive a few months of her probation to allow her to complete that evaluation. We would also ask probation to terminate upon completion of the evaluation and any necessary treatment. Ms. Curry is challenged residentially at the moment, as well as with employment due to her the past 22 days in custody. So we want to make sure she lands on her feet and has time to comply with all conditions.
I will waive probation fees until the end of this year. Any objection to non-reporting, Mr. Pellon?
That would be state's request, non-reporting as opposed to termination.
Okay. Ms. Curry, once you've completed the evaluation and any treatment that's required, then your probation will be non-reporting, which means that you won't have to go back to probation after the evaluation is done.
Mm-hmm.
But if you get arrested again, or if you violate any of the other conditions, your probation could be revoked.
Okay.
Anything else, Mr. Dotis?
Nothing further, Your Honor. Thank you for your patience.
Thank you.
Your Honor, position number 10 and 11, please.
And this will be a negotiated plea, Your Honor.
Position 11. This is State versus Justin Farrell, 21 CR 003598J. Mr. Farrell was accused of simple assault and disorderly conduct from a July 1st, 2020 incident. Mr. Farrell, you have a right to remain silent, and your attorney is going to be Mr. Dotis. Anything you choose to say during the course of these proceedings, your statements can and will be used against you. This is going to be a negotiated plea hearing. So, Mr. Farrell, please raise your right hand and unmute 5 South. Do you solemnly swear and affirm, Mr. Farrell, that the statements you make can and will be used against you?
Yes, ma'am.
Sorry, I'm getting all my oaths confused. Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Doris, please hold. 4 North, who do we have?
Position 12, Gresham.
Okay, thank you. Just wanted to be sure. All right. So, Mr. Pellon, I'm so sorry to confuse you, but I got distracted by 4 North.
That's fine, Your Honor.
What is the plea offer for Mr. Farrell?
Yes, Your Honor. State's recommendation for position 11 is 12 months to serve. I believe it'll be 38 days, credit for time served 19 days.
Okay.
Balance probated, 8-week anger management course, no further contact with Samuel Solomon or Lakeisha Bentley, and a stay away from 80 Jesse Hill Junior Drive.
All right, that would be Grady Hospital. Would it be with the exceptions of unless seeking emergency treatment or having an appointment?
State would prefer emergency treatment only, Your Honor.
And Your Honor, we would ask that it just be emergency treatment or valid appointment. Mr. Farrell does receive housing vouchers that he needs to get through the Grady location, but he is clear that he cannot return unless he has a valid appointment or medical emergency.
Yeah, I'm sorry, Mr. Pellon, I have to go with both, considering it's a public service hospital.
I understand, Your Honor.
All right. And Mr. Dotis, in addition to that, do you stipulate to the factual basis, venue, and ID?
We do so stipulate to the 3 elements for the purpose of this plea, Your Honor.
All right, thank you. Mr. Farrell, have you consumed any medication or alcohol recently? And have you understood the proceedings so far? We'll need to keep 5 South unmuted, please. Have you understood the proceedings so far?
Yes, ma'am, Your Honor.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained to you that if you decide to enter this plea, you will be giving up your right to a trial, to confront your accuser, examine witnesses, challenge the evidence brought against you, present any defenses you may have, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of simple assault and 1 count of disorderly conduct occurring at the Grady Hospital?
Guilty, Your Honor.
Your sentence is 12 months to serve 38 days, credit for time served 19 days. If you have no other cases holding you at the jail, you will then be released within 24 hours. You will report to probation next Thursday before 3 p.m. While on probation, you will complete an 8-week anger management program. At all times, you are to stay away and have no contact with Samuel Solomon and Lakeisha Bentley. You also cannot return to Grady Hospital unless you are seeking emergency medical treatment or you have a valid appointment with a qualified healthcare provider. But if you just happen to stroll into Grady Hospital, we'll make sure that you stroll back to the Fulton County Jail. Is that understood?
Yes, ma'am.
Thank you. That concludes this case.
Your Honor, we would request it to switch to non-reporting upon completion, and if this court could waive a few months of his probation fees, as Mr. Farrell is residentially challenged.
I will waive his probation fees till the end of this year, and then Mr. Pellon, what about the non-reporting?
State doesn't object to that, Your Honor. And also to clarify for the court, our office will move to null pros position 10.
All right, thank you. Position 11, on position 11, it'll be non-reporting after completion of conditions. And position number 10 is null pros. Thank you.
Position 12, Gresham.
Mr. Dotis, you are still in demand. You have Marlon Gresham accused. That was your client, right?
Yes, Your Honor. I did speak with Mr. Gresham, and I believe this will be a non-negotiated plea.
Okay. This is State versus Marlon Gresham, accused of fair evasion and criminal trespass. And this stems from an August 22nd, 2023 incident. Mr. Gresham, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Angelo Dodes. This is going to be a non-negotiated plea hearing, which means that, Mr. Gresham, I'm first going to hear from the prosecutor as to what their offer is and the reasons why they are making that offer. And then I will hear from your attorney. I will then let you know which offer I'm going to accept, keeping in mind that I have the discretion to reject both and set the case for trial. But I will let you know what my decision is before we proceed. Mr. Pellet?
Your Honor, state's recommendation was 12 months to serve 30 days. I'd have to double check the credit for time served, but I believe that is not insignificant. Balance probated, an anti-theft course, and stay away from all MARTA location.
All right. And I'm just
And
looking.
I presume defense will raise that he'd prefer that as comply with all MARTA suspensions, and state would not object to that.
All right, to stay away from all MARTA property in accordance with any active suspension. So that, was that the only point in dispute, Mr. Dodes?
Your Honor, our main point is the anti-theft course. Mr. Gresham has just been charged with fair evasion and criminal trespass. I've spoken with Mr. Gresham regarding the criminal trespass. He was unaware of the suspension, but I reached out to MARTA and was able to confirm that his suspension will be lifted on September 29th. So he's clear he needs to stay away until then. Regarding the fair evasion, I provided Mr. Gresham with a list of resources that can help him land back on his feet monetarily, as well as help him look into programs that can subsidize his use of MARTA so that he can still get around the city. Mr. Gresham is currently homeless. He was last working at a temp agency, which he's hoping to get started again, but he does not currently have stable employment or any way to pay for an anti-theft class. Again, he had issues allegedly paying a fare. This anti-theft class, costs hundreds of dollars. I think that there are better ways to help Mr. Gresham avoid instances in the future.
20 hours of community service would be the substitute.
You want to switch over to 91?
And Your Honor, part of the reason for state's recommendation is that Mr. Gresham had a different case that was resolved, I believe, Tuesday, so 2 days ago, is involving the exact same charges at the exact same location. And
I noticed, yeah.
I could be recalling incorrectly, but at that time, I believe defense counsel's position was that Mr. Gresham had a job, that he had to use MARTA to get to that job.
Your Honor, I was not here on Tuesday. That was a different attorney. When I spoke to Mr. Gresham, he did mention that he was working at labor staffing temp agency. I'm not trying to mislead the court, but that's not a permanent job. He's not sure if that's waiting for him. Again, I'm not sure why both of these cases were not on the calendar to address on Tuesday. But
did he get an anti-theft class also in the prior disposition?
He did not, Your Honor.
Yeah.
Okay.
That was simply
I honestly don't know if this gentleman can afford the anti-theft class. But if he's not going to pay for an anti-theft class, he's definitely going to do community service. So, Mr. Dodes?
And I just asked Mr. Gresham, are you okay with the 20 hours of community service to resolve this case?
Yes, sir, Mr. Dodes.
I'm sorry?
Yes, sir. Yes, sir. Yes, I am. I do agree.
All right, this will be a.
I do agree with the 20 hours of community service. There is no way at this time that maybe we should pay for a anti-theft class. Or even get there since I'm suspended for public transportation.
Okay, Mr. Gresham, that's all. Thank you. And Your Honor, we'd like to go forward with the plea.
Thank you. Mr. Gresham, if we can unmute 4 North, do you, have you consumed any medication or alcohol?
I do get medication, but I'm not under the influence in any way of the medication.
All right, thank you, sir.
Decisions.
I appreciate that. Thank you. And are you satisfied with your attorney services?
Yes, I am, Your Honor.
And have anybody forced you, induced you to take this plea for this particular case?
No,
I beg your
No.
pardon?
no,
And has it been explained to you that if you decide to plead guilty to these charges, that this would be additional count convictions on your criminal history record?
I understand that, Your Honor.
All right, you've already got the same charges of same convictions from a February 10th incident, and now this would be the same convictions from an August 2023 incident.
Yes, I understand.
And do you understand that any subsequent arrest could risk the chance of you getting a permanent ban from all Marta property?
I understand that, Your Honor.
All right, so are you still freely and willingly moving forward with this plea?
Yes, I do. Yes, Your Honor.
Do you waive your constitutional right to a trial, to be able to confront your accuser, examine witnesses, challenge the evidence brought against you?
Yes, Your Honor.
And have the state try to prove the charges against you beyond a reasonable doubt?
Yes. Yes, Your Honor.
How do you plead to one count of fair evasion and one count of criminal trespass from August
plead-
2023?
I plead guilty, Your Honor.
Your sentence is 12 months to serve 30 days, credit for time served 17 days, credit for time served 17 days. Yeah. And the rest of the time will be on probation. If you have no other matters holding you at the Fulton County Jail, you should be released within the next 24 hours. You must report to the probation office next Thursday, and that will be at 132 Mitchell Street in downtown Atlanta. You'll report to that office before 3 p.m. While on probation, you will complete 20 hours of voluntary community service at any nonprofit agency which is not a school and not a religious organization. In other words, no school and no churches. You're also to stay away from all Marta property and facilities like their trains and buses and stations in accordance with all active suspensions that are against you. Currently, Mr. Dotis informs us that your suspension will probably expire by the end of this month, but I highly recommend that you call Marta to confirm that. I will waive your probation fees up to and including up to the end of this year. And you will continue to report to probation as long as you haven't completed the community service. After that, your probation will be non-reporting. Any questions, Mr. Gresham?
No, ma'am, I just want to make it clear, if I complete my 20 hours of community service as the court has demanded, will my probation be unreported probation or suspended probation?
It will not be suspended. It will be non-reporting, which means that you don't have to report. However, if you get arrested again, or if you violate any of the conditions of the regular probation, then, well, you'll be back to square one.
I understand, Your Honor.
Thank you.
Thank you.
Position number 32, Mr. Stevens.
Thank you.
Okay. And Your Honor, this is also position 9. I believe position 32 was a typo and was an FTA.
Yep, you're correct. So this will be your case.
Yes, Your Honor.
All right. This is State versus Stephen Dedrick, accused of obstruction of a law enforcement officer and theft by shoplifting from a May 24th, 2021 incident allegedly occurring. Well, I'm going to let counsel go through the location. In case number 21 CR 2514A. That's position 9 on our calendar. Mr. Dedrick also has position 32, in which he's charged with a bench warrant matter, and this is 23 FTA 779. So I understand this is going to be a plea hearing. Would that be correct, Mr. Dotis?
Yes, Your Honor, we would ask, there is a $300 fine the state is asking for. We would ask for that fine to either be suspended or converted into community service hours. Mr. Diedrich is residentially challenged and unemployed at the current moment, so he will struggle to pay that fine in addition to the classes that the state is asking him to complete.
And Your Honor, I can clarify this when I read through the state's recommendation, but that fine is a statutory requirement. The courses that the state is recommending are not a statutory requirement.
How old is Mr. Dedrick Stevens? It's either Stephen Dedrick or Dedrick Stephen.
Dedrick is the last name, Your Honor.
All right, Stephen Dedrick. How old is he?
Your Honor, how old is he? 30, Your Honor.
Position number 9. I only have a Wisconsin address on Mr. Dedrick Stephen or Stephen Dedrick. Why am I waiving probation fees? Young man who lives out of state?
Your Honor, Mr. Diedrich is residentially challenged. He stays in the Atlanta area. That may be an old family address, but it's not one that he currently uses.
Is he receiving any public benefits like SSI or anything like that?
No, Your Honor, my client says no.
I'm sorry?
My client is, I asked earlier and I asked again, and my client says he's not currently receiving any benefits.
Okay.
I have provided him with a list of resources to help him land back on his feet, so future incidents will be avoided.
All right. I will waive probation fees for the month of September, but he needs to get cracking and get a job.
Understood, Your Honor, but our main concern would either be converting the fine to community service hours.
No, it's not. He's going to have the rest of 12 months to get a job and pay that fine.
Understood, Your Honor. You want to proceed? Your Honor, I'll need a second to talk with Mr. Diedrich.
All right.
Can we mute the principal?
Can we do positions 1 and 2, Mr. Boswell?
At 4 North, that would be Mr. Dodis's client, so I have to wait till we are done with courtroom 2.
I believe Mr. Dodis has the same case as I do, Your Honor. If you can get anything that's later than position 18.
Let's see. Do we have any other cases for Mr. McLean? At 4 North, it would be positions 19 onwards.
I got position number 29 coming up next.
All right. Thank you, Deputy. Mr. Dodis, I would need Mr. McLean at the laptop if you want to discuss with Mr. Stevens on the sidebar. Joshua Smith? Is that Joshua Smith at 4 North?
Yes.
Okay.
And if Mr. Pellin could check the Zoom chat, I left him a message.
I didn't catch that, Your Honor, but if
Neither did I.
Dodis can hear me, I am responding to your chat question.
My apologies, the mic is very low.
Well, I will.
Okay.
Chat.
Addressing 4 North, I have case number 21 CR 50J, Mr. Joshua Lamar Smith, accused of battery, family violence, and cruelty in the 3rd degree, stemming from a December 24th, 2020 incident. Mr. Smith, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. So I have a recommended plea offer printed on my calendar, but I'm not sure if that's what we're going with. So, Mr. Pellin, what's the plea offer for Mr. Smith?
I know.
That's my case, Your Honor.
Oh, I'm sorry, Miss Allen. Yes.
No
what?
problem at all. So Mr. Smith on my calendar is position.
This is Joshua.
Joshua Smith, right. So position 29.
Yes.
12 months to serve, 365 days.
Okay,
And the question we had was how much credit does the state intend that to have? If it's gonna be time served, we could do a plea. Otherwise,
Obviously, we're going to give him credit for the days he's been in jail related to this case. So
Right.
let's look at the jailing page and see. I can go do that now.
Okay.
I had 39 days.
Okay.
And I believe on a time before, there are several months.
That was in January 5th, 2021. That was on a probation violation. And it was 194 days.
If it doesn't credit to this, Your Honor, this is not guilty. And we would go to the jail jury to the trial calendar.
Miss Allen? He was booked in on January 5th, 2021 and released on July 17, 2021. He had a surety bond and a probation violation for which he received time served.
And that was related to the battery and the cruelty from December 2020?
The probation violation? No, that was
No.
related to a felony matter.
So this is in a bench warrant case.
He was booked on the bench warrant on July 31st, and he's been in custody now for 39 days.
And his previous time on this charge and on this case. Let me,
194 days.
related to these charges?
Right, we're looking at booking number 21.
Sir, I understand. I'm just trying to follow through. Let me look it up and review it,
yes.
okay?
And Mr. Jordan, may I have screen share rights, please?
So I believe it would be fair to say that this also caused him to have the 194 days.
I'm just reading off the numbers, but I need screen share rights, please. Thank you, Mr. Jordan. All right, everyone can see this now? On
Yes,
booking
Your Honor.
number 21-00153, Mr. Smith was booked in on January 5th, 2021 and released on July 17, 2021 on a probation violation matter, as well as the case that we have presently.
Yes, so he should certainly get credit for that time based on him being in jail on those charges. That would never be something we would argue about.
Okay, and so it's 194 days.
Yes, thank you.
Okay, and then he was booked on the bench warrant on July 31st.
So 39 additional days.
Correct.
Correct.
So
If this is essentially, that's what he and I discussed. He believing to be essentially a time served sentence, Your Honor, that would be a plea.
Ms. Allen?
That is what the case notes show and what his credit should be. Although I'm not a math expert, I just did the math quickly. I believe that's 233 days he would get credit for that he's already served in relation to these charges, even though he failed to appear. Yes.
And the sheriff typically gives a 2-for-1, so which means that.
I understand.
So that his time for this particular case would be concluded.
Whatever the sheriff is going to give this person credit for based on the fact that he served 233 days, that's outside of my control. And I believe these are cases and offers that are dealt with on a daily basis. I'm not sure why this is something that is confusing, but yes, absolutely.
Okay.
Thank
Mr.
you.
McLean, are we all on the same page about time served then?
Everybody's well. Not everybody.
Mr. McLean, does your client want to proceed?
I believe so, Your Honor. We had a freezing up on our screen. We thought everybody was frozen, and now it's telling us our internet connection is unstable. But yes, Your Honor, my indication, my conversation with him was, this is essentially time served, then that's a plea. Yes, Your Honor.
This is the time served based on the 2-for-1. And in that case, we will proceed. Can Mr. Smith please raise your right hand? You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you.
Your Honor, in addition, at this point, since this is a plea, the state is also requesting no further contact with the victim in this case. Sherry Nelson.
Miss Allen, I'll be glad to put that as part of the disposition, except the time during the no contact enforcement has expired with this sentence. So it would be very advisable for the alleged victim to seek a protective order if there is still grounds to seek a protective order.
Certainly, my understanding is she's receiving phone calls now, so I'll make that information known. Thank you.
Otherwise, the state has the option to withdraw its plea and move forward. Okay. And has the victim been consulted with regards to this?
Yes, Your Honor.
Okay. Mr. McLean?
Yes.
So I guess it's 12 months to serve 365 days, credit for time served 233 days, and no contact with the alleged victim. And I'm sorry, her name again, please? Cherie Wilson?
Ma'am, I'm here in the court. My name is Cherie Nelson, and if it's possible, that can be included in there, but there's no further contact. I do have text messages.
I cannot talk to someone whose name is Galaxy S20 FE5G, and I have no clue who's talking.
The
video is not on. All right. Good.
My name is Cherie Nelson. I'm the victim.
And you are going to go put on a jacket?
Yes, ma'am.
Thank you.
Excuse me, my information from our victim advocate services is that they responded and spoke with Miss Cherie Nelson.
That's perfectly fine. If she's appeared and she wants to chime in, that's her right. Ms. Nelson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms.
Thank
Nelson, are you the individual involved with Joshua Lamar Smith?
Yes, ma'am, I am.
Okay, he's been in custody now for about 39 days. Have you received any communication from Mr. Smith during the last 39 days?
Not in the last 39 days, no, ma'am.
Okay, when was the last time Mr. Smith communicated with you?
I would say maybe in June, and it was threats. I did go ahead and get a police report from Gwinnett County regarding this.
And what was the nature of that contact?
I do have a screenshot of where he was threatening me. He had a female even called my phone a couple of times in February. It continued in March, June, and like I stated, I have screenshots where he was threatening me, telling me he was going to, I guess, harm me, the type of vehicle.
Just one second, Ms. Nelson, just one second. Yes, Mr. McLean?
This is from another county. We really must object to this.
I had moved, sir.
We have before us a 2020 matter that we're trying to resolve here. I understand where the court's going, I believe, but Your Honor, if she's got a Gwinnett County case.
I'm just trying to find out. Mr. McLean, this is not a jurisdiction issue. I'm trying to find out whether I can move forward with this plea, since if I accept the recommended sentence, I cannot institute a no contact order because it would have lapsed. So now I have a victim who's appeared and who has an issue with the sentence, the way it's framed.
Right, it is the maximum sentence, Your Honor, and he does have the credit for it. And we
only if I accept the guilty plea. And your client understands that I have a right to also not accept it if I don't believe it's in the best interest of the victim.
Well, Your Honor, in a sense, since he's already served the time that comes with the charge, it is incumbent upon us to release him.
All right, let's just get back to law 101. He's not convicted. He's got a bond. He's in jail because of a bench warrant. He's not served the time on any conviction yet. He's just in jail on a bond or on a bench warrant. That's the situation. If he has served the time, it's not on this case because there's no conviction in this case. And I want to make sure that everyone's on the same page about that. All I want to know is if Miss Cherie Nelson understands that if I accept the plea today and I sentence him, I can say no contact with Cherie Nelson, but it will have no impact because the sentence will be concluded and that would be it. In the alternative, I can require that the sheriff put him, that he serves the time out day for day, no 2-for-1 option.
Your Honor, I don't think the court has the authority to deal with the 2-for-1 option.
Mr. McLean, the 2-for-1 option is a policy at the sheriff's discretion. But if the sentence sheet requires him to do a day for day, then the sheriff has to comply with it.
Your
And
Honor,
this is not an unusual circumstance. It has happened many, many times before. Unless there's a statute that says I can't, then I'm sure and I will respect that accordingly.
we believe there's case law on it, Your Honor. Respectfully, we disagree. I think this goes back to even the Foxfire cases.
Okay. So I am going to proceed with my voir dire of the alleged victim to make her understand that if she wants a protective order, that this sentence is not going to give it to her. Ms. Nelson?
Yes, ma'am.
I understand that, Mr. Smith, that you don't want to have any communication, but if I accept his guilty plea to this charge and I sentence him, I can say no contact with Cherie Nelson, but it won't mean a thing because his time for this sentence would have been completed due to the time that he served in the jail.
And Judge Loudby, do you mind if I can speak real quick in regard to that?
Yeah.
Yes, ma'am. Like I told you, in between that time, the contact has happened in Fulton County and Sandy Springs where I live, where I currently moved to Gwinnett County. Since I was in Gwinnett County when some of this contact has happened, I was advised by a police officer there to obtain
a temporary protective order.
A protective order, but I had to get it in Fulton County where he resides. I tried to get a warrant regarding this because of the harassment and the threats. He does not have a forwarding address. He uses an address in College Park that he does not reside in, meaning if he was not served, it meant nothing. So I had nothing but to endure the harassment all this time. And like I stated, I do have messages. I have pictures where he's trying to brag about a car. He's giving my phone number out to females, having them call.
Ms. Nelson, thank you very much. The plea is rejected. You can go ahead and file your application for a protective order in the Fulton County Superior Court, and you may have him served at the Fulton County Jail.
Yes, ma'am.
Fulton County Superior Court does have hearings with jail cases.
And I've already communicated with our victim advocate to make sure this young lady is supported through the process of obtaining a TPO and facilitating service while this defendant is in the jail.
All right, please unmute phone off.
Your Honor, in this situation, we believe that the situation would necessitate a signature bond for him.
I'm sorry, Mr. McLean, please repeat.
We believe this situation would necessitate a signature bond for him. He has served the time that comes with the charge.
Let me see, what are the grounds for a signature bond then? First of all, yes, Mr. Smith, do you have a right to remain silent? Things are not looking very pretty. So if you want to say anything, your statements can and will be used against you. What would you like to say?
Okay, Judge, I'd like to say first and foremost, this case, like you said, from 2021, this is actually my ex-wife. We're no longer together no more. We've been divorced since last year of March. So I would like to say some of the things that she's saying.
Why don't I stick with my argument about the signature bond? We don't need to get into a lot of facts that are not this case. I understand what he's saying, but this is from 2020. And I'd like to go ahead and ask for a signature bond from the board.
Okay. So, thank you, Ms. Nelson. There is no plea today. I'm not sentencing him, but you can mute your screen and we're going to address a bond modification.
Yes, ma'am.
All right, so right now, in this particular case, I've got a bond forfeiture that was entered on December 22nd, 2022.
Your Honor, we can reset this case a week. We're looking at something on the screen, and 1 week reset would be fine, or we stay further.
All right.
Wait, but are you asking for this gentleman to receive a signature bond? You just don't want Judge Law to make a
No, no.
decision about it?
No, that's not what I'm saying. I see
Okay.
on the screen, something that's going to hold him, so I don't need to be pressing for a signature bond because I don't want to waste the court's time.
All right. That's not a problem. I can reset the case to September 14th. And that will be addressed, I think I'm on trial, so it'll be addressed by another judge. But the notes will be on case file that that I rejected the plea on the grounds that the victim has serious concerns.
Your Honor, what Judge hears is not our concern.
That the victim has serious concerns about the about the defendant allegedly attempting to communicate with her.
Judge, I would like to say I haven't had no contact with her at all. I have not talked to her at all.
Mr. Smith, that's not for me to decide right now because I have nothing, I have no motion to revoke your bond. I have no motion to, all I have right now is just a pending case against you. But I'm not going to accept the plea because the alleged victim is not satisfied with the way the plea is framed. Okay, so Ms. Nelson, you're free to go. Mr. McLean, I'm going to grant your request to reset the case to September 14th. And the bond and the current situation in this case remains the same. As I said, I know he's been in custody in excess of 200 days, but this would be credit that would be given to any sentence in the event that he is convicted of this offense. Presently, he's not convicted. He has let me check his bond status. Presently, he has a $21,000 bond. It's $20,000 on the battery family violence and $1,000 on the criminal trespass causing damage to property. The $21,000 on the battery family violence is for this matter, and the $1,000 criminal trespass is from a December 6, 2021 incident. So that's the bond he has currently.
Understood on the bond, Your Honor, but we'll reset the case if we could and look into the other matters.
All right, thank you.
Position numbers 13 and 14, Mr. Griffin. Come on, Mr. Griffin. Yeah, I see it. You should share to the middle.
Oh, did you say Mossy Griffin?
Griffin.
That is what they said, Your Honor. That just only said the last name.
Okay. So make sure I'm on the right.
At positions 13, 14?
Yeah, that would be correct. Okay, this is Mr. Mossy Griffin, accused of criminal trespass in 22 CR 7514D from a November 1st, 2022 incident. And Mr. Griffin has also got a second case for a bench warrant stemming from a March 8, 2023 incident. Mr. Griffin, you have been advised of your right to remain silent, and your attorney is Mr. Angelo Dodis. And Mr. Dodis, how are we moving forward? This is going to be a negotiated plea?
Yes, Your Honor.
Okay. Mr. Griffin, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right. Mr. Pellin, what is the state's offer?
State's recommendation, Your Honor, is 12 months to serve 30 days, credit for time served 16 days, balance suspended.
Is that the terms to which your client has agreed? And do you stipulate to the factual basis, venue and ID, Mr. Dotis?
Yes, Your Honor, we do so stipulate for the purpose of this plea.
All right, thank you. Mr. Griffin, have you consumed any medication or alcohol recently?
No, I haven't.
And have you understood the plea offer as has been explained to you?
Yes, I have.
And are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you, inducing you to take this plea today?
No.
And do you I'm sorry?
But I'm not.
If you decide to enter this plea, you will be giving up your right to a trial, to go back to court and confront your accuser, challenge the evidence brought against you, examine witnesses, present any defenses if you have any to present, and also to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Understood. Yes.
And how do you plead to one count of criminal trespass?
Yes.
Your sentence is 12 months to serve 30 days, credit for time served 16 days, balance suspended. That concludes your case, and the bench warrant matter is going to be closed out by null pros. Thank you.
Position number 6, Mr. Davis. Come on, Mr. Davis. Have a seat.
Process. And Your Honor, for position 6, this is going to be a not guilty plea and a waiver of arraignment.
All right. This is State versus Brandon Marcus Davis,
Yeah, ma'am.
and his case number is 23 CR 5183E. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Your counsel is going to be filing a waiver of arraignment and enter a not guilty plea on your behalf. Mr. Dotis, please direct the document to Ms. April Champion.
Yes, Your Honor.
Your case is going to be further notice for a jury trial, and that concludes your matter. Thank you.
And Your Honor, so the court knows, bond is moot today. Mr. Davis has paid bond on this case.
All right, so he's going to be released on bond?
Your Honor, he's waiting for a transfer on a hold, but this case is not holding.
Okay. Please make sure that he keeps his current address with the court so that when his case is called for trial, we have the correct address to send him his notice.
Understood, Your Honor. Thank you.
Thank you.
Proposition number 8, Mr. Sutton.
Okay.
Position 8. And
What number was that position number, Mr. Dotis?
Proposition number 8, Mr. Sutton.
Sutton, Sutton?
Correct.
I have position 33 for that. Would that be correct?
Mr. Sutton is on the conference calendar. They're not ready for that calendar yet.
All right. Sergeant, we'll be addressing that very shortly.
Can I do position 1 and 2, Mr. Boswell?
Okay, thank you. Mr. Daryl Boswell is at 4 North, and Mr. Boswell is got a theft by shoplifting case in 22 CR 7610D, stemming from a September 2021 incident. Mr. Boswell also has a bench warrant, 23 FTA 776. Mr. Boswell, you have a right to remain silent. Anything you choose to say about the facts of your cases, your statements can and will be used against you. You have a right to an attorney, and Mr. Dotis will be your counsel. And Mr. Dotis, are we still proceeding with a negotiated plea?
Your Honor, this should be a negotiated plea. We would ask if there is a $500 fine, we'd ask that to be converted to 50 hours of community service. Mr. Boswell currently does not have stable employment and wants to make sure he can meet his obligations to the anti-theft course and land back on his feet after his time in custody.
And Your Honor, state's requesting that because it's a statutory requirement.
I'll amend that to a $50, 50 hours of community service. I'll waive his probation fees for the months of September and October and November. From December 1st onwards, he will pay his probation fees. And Mr. Pellin, do you have Mr. Boswell's criminal record history, please?
Yes, Your Honor. So, Your Honor, I have The most recent convictions are 3 convictions out of 2017. The first was a false name to law enforcement, a PI charge, and 2 S battery charges. 2017, another PI charge, and a 2017 shoplifting. So those are the most recent convictions. I have probation violation arrests from 2018, 2019, and 3 counts from 2021, and also a 2021 obstructing law enforcement charge that I did not see. Gosh, I can't think of the term. I didn't see how it was resolved.
All right, thank you. Mr. Dotis, I don't have a problem amending the $500 fine to 50 hours community service, but he'll be reporting to probation every month. So from December 1st, he would need to start paying probation fees. Would he still like to proceed with the plea?
Mr. Boswell, knowing that you'll need to report, and that your fee, instead of the fine, you'll have 50 hours of community service like we discussed. Do you want to go forward?
Yes.
And Your Honor, I did explain all of the options, what may happen, and he did understand that it was going to be at Your Honor's discretion, so he is well informed and prepared to enter a negotiated plea.
All right. Mr. Boswell, do you understand that you'll be reporting to probation every month for the next 12 months, 11 and a half months? And that you will need to start paying probation fees from December 1st onwards?
Ma'am.
All right. Do you still want to move forward with the plea?
So it won't become non-reporting, and how much is the probation fee?
You will not, it will not become non-reporting. The probation fees is about $50 a month.
Yes, ma'am. Yes, I want to plead. Yes, guilty.
All right.
Your Honor, he does have a hold for East Point also.
All right. And what's the hold at East Point for?
It appears it's a FTA for it's a misdemeanor FTA. That warrant was signed June 10th of 2022.
Do you know what the charge is for?
It's not listed in the underlying charge, Your Honor.
Okay.
And Your Honor, he is cleared. We just discussed that hold. I don't know what the underlying charge is, but he does know he'll have to go handle that in Henry County before he can start his probation.
Okay. Well, as long as he reports to probation on time, then there won't be any reason to revoke his probation and have him arrested again. So I'll move forward with this plea. Thank you, Ms. Tyson. Mr. Boswell, okay, so let's proceed. Mr. Boswell, please raise your right hand. I don't know if I swore him in, but do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Mr. Pellin, go ahead. Did you already allocate the offer or?
No, Your Honor, we just discussed the fine earlier.
Okay.
Your Honor, state's recommendation is 12 months to serve 34 days, credit time served 17 days, balance probated, a $500 fine, anti-theft course, and stay away from 6149 Old National Highway in South Fulton. That's a Walmart location.
Okay. Mr. Dotis?
Your Honor, our internet is unsteady. I caught the end of what Mr. Pellon said. I believe he just went over the state's offer. As long as we touched on the community service, then we would stipulate to the factual basis, venue, and ID for the purpose of the plea.
He did require the $500 fine, but as the court has indicated, it would be amended to 50 hours of voluntary community service.
Understood. Thank you. Yeah, again, we're cutting in and out, so my apologies if I repeat or talk over anyone.
Can you hear me though?
I can hear you now, Your Honor, but a minute ago I could not hear anyone.
Okay. Stop me and interrupt me anytime that you can't hear what I'm saying, okay?
Understood, Your Honor. Thank you.
Mr. Boswell, Mr. Dotis, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, for the purpose of this plea.
Thank you. Mr. Boswell, have you consumed any medication or alcohol recently?
No.
You need to repeat your answer loudly.
No.
And have you understood what's been going on so far?
I didn't hear all what he said when it blipped out, but I think it was just about like $500 fee will be taken down to 50 hours of community service.
That
And,
would be
I have to
correct.
report every month with $50 probation fee. So
Correct. And those probation fees will kick in on December 1st of 2023.
yes, ma'am. Thank you.
All right. So have you understood everything then so far?
Yes.
And are you satisfied with your attorney?
Oh yeah, Mr. Dolis, he's great. He's great.
All
Mr.
right.
Dolis, great. Thank you. Mr. Dolis.
And Mr. Boswell, if you, is anyone forcing you, inducing you to take this plea today?
No, ma'am.
And if you decide to plead guilty to this charge of theft by shoplifting, as far as I can tell, this will be your second theft by shoplifting conviction on your record.
Yes, ma'am.
And if there is a fourth arrest, if you have 3 convictions and there's a fourth arrest, that will be a felony charge as a matter of law. Has that been explained to you?
Yes, ma'am.
Do you willingly give up your rights to a trial, to confront your accuser, to examine witnesses and evidence brought against you, to be able to present any defenses if you choose to do so, and to have the state try to prove the charges against you beyond a reasonable doubt in a court of law? Do you give up these rights?
Yes, ma'am.
How do you plead to 1 count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 34 days, credit for time served 17 days. Once you are released, and if you're released from the Fulton County Jail by this week, you have to report to the probation office next Thursday before 3 p.m. and that will be at 132 Mitchell Street. I'm not sure if East Point is going to come pick you up or whether you're going to be released and then you can go to East Point on your own.
Okay.
I'm not sure about that. But if you are released, you must report to Fulton County Probation next Thursday before 3 p.m. Understood?
Yes, ma'am.
Your probation fees are waived up to the end of November of this year, and you will start paying probation fees from December 1st onwards. And you will report to probation every month. While you're on probation, you will complete 50 hours of community service at any nonprofit agency that's not a school and not a church. You will also complete an anti-theft class. At all times, you have to stay away from the Walmart store at 6149 Old National Highway in South Fulton. That concludes your sentence. Thank you.
Position number 7, Davis.
I had something. All right, this is Clyde Leviticus Davis, 20 CR 4148Y. Mr. Davis was charged with theft by shoplifting from a December 8th, 2018 incident. Okay. And Mr. Davis, you've been advised, I'm sorry, you have a right to remain silent. Anything you choose to say about the facts of your case, your statements can and will be used against you. You have a right to an attorney and you are represented by Mr. Dotis. Mr. Dotis, this is going to be a negotiated plea. Would that be correct?
Yes, Your Honor, we would ask the $500 fine to be converted into community service. Mr. Davis is currently struggling with employment and housing. So we would, and does understand he'll need to pay for the theft course. I provided him with resources as well as a theft course recommendation, but we would ask that to be community service instead.
Put your mask up.
Mr. Pellin, do you have Mr. Davis's pretrial history or conviction history, if any?
Yes, let me pull that for you, Your Honor.
No. Go ahead and say it.
Your Honor, this defendant has 17 cycles in Georgia and 5 in what appeared to be cycles just in the prison system, which I haven't seen before. The most recent convictions are 2022 probation violation, 2021 shoplifting, 2019 shoplifting, 2019 obstructing a law enforcement, and then jumps back to 2014. My most recent arrests are 2021 FTA, 2019 forgery in the 4th degree and obstructing law enforcement, 2018 shoplifting, and then I'm back to 2014 again.
Okay. Mr. Davis, I will amend the $500 fine to 50 hours of community service. I will waive his probation fees until the end of November. He will be on active probation for the rest of the 11 months, and he starts paying probation fees from December 1st. Otherwise, his probation will be revoked and he might end up spending the rest of the time in prison.
Understood. Your Honor, I would note Mr. Davis does have another matter in Henry County that he'll be released to. He is clear that upon completion of that, the first thing he needs to do is contact his probation officer. But I do just want to make the court aware that he may not be able to report by next Thursday.
Okay, in that case, I will waive his probation fees for the first 2 months.
And he is on active probation out of Jackson County for a forgery in the 3rd. He had 5 years probation. He was sentenced August 24th of 2023.
And what's the status of that probation? Does he have a revocation matter?
I'm not sure. It's out of Jackson County, so I'm not sure.
I believe after entering that plea, Your Honor, I believe he was transferred to Fulton County, so he hasn't had a chance to. He's remained in custody since that, so he hasn't had a chance to formally begin his probation.
All right, I'm going to waive probation fees for the 2 months, and he reports to probation as soon as he's done with his Henry County hold. And then he starts paying probation fees after the first 2-month waiver. And it's active probation reporting for the rest of the time. And probation in Fulton County is suspended until he's handled all his other holds. It gets told. So Mr. Dotis, does your client understand that?
Yes, Your Honor. This is what we discussed. Is that everything clear, Mr. Jones? Okay. Yes, Your Honor. We're prepared to go forward with the plea.
All right. Mr. Davis, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Okay. Mr. Pelham, you've already allocated the terms, right?
Yes, I do.
I don't believe I have, Your Honor.
All right, go ahead.
They've been pretty well discussed. 12 months to serve, 30 days, balance probated, $500 fine, anti-theft course, and stay away from 1275 Caroline Street Northeast. That's a target location.
All right. Mr. Dotis, do you stipulate to the factual basis, venue, and ID, keeping in mind that the $500 fine is amended to community service and probation fees are waived for the first 2 months?
Yes, Your Honor. We are clear. We do so stipulate. And yes, we are clear on everything.
Mr. Davis, I'm sorry. Mr. Davis, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yeah. Yes.
Okay, now you are fighting with noise in your background, so you'll have to speak up, okay?
Yes, I do understand what you're saying, Your Honor.
And are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you, inducing you to take a plea today?
No, there isn't.
And has it been explained to you that if you enter a guilty plea, this will be another theft by shoplifting conviction on your record?
That is correct, ma'am. I understand that.
And you understand that any subsequent arrest, if this is conviction number 3, any subsequent arrest for shoplifting will be a felony.
Yes, ma'am, I do understand that.
All right. And do you give up your constitutional right to a trial, to go back to court with your attorney, to confront your accuser, challenge the evidence and the witnesses that may be brought before you?
Yes, ma'am, I do at this moment.
All right. And to have the state try to prove the charge against you beyond a reasonable doubt?
Yes, ma'am, I do.
How do you plead to 1 count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served. I believe it was 15 days. Was that correct, Mr. Pelham?
Your Honor, I actually did not read it out to the court. My understanding is it's credit for time served 7 days.
Yeah. Yes, Your Honor. He only has credit for 7 days, but he is clear on that, that he will have some time here before he's transferred to Henry County.
So he will have additional time to serve at the Fulton County Jail, which means he has about another 7 or 8 more days to serve at the jail.
Yes, Your Honor.
That's correct, Your Honor.
Okay. Once he's completed with his time and once he's resolved any other holds, he will need to report to probation at 132 Mitchell Street, where he will complete, where while on probation, he will complete 50 hours of community service, pay and complete an anti-theft class, and stay away from the target at Caroline Street in Atlanta, Georgia. He is his probation fees will be waived for the first 2 months, after which he will be on active probation for the remainder of the 11 months that is on probation. And he will pay the probation fees beginning on the 3rd month of probation onwards. Thank you.
Position number 32, Stephen. Come on, Stephen.
32.
And this is position 9 again as well, Your Honor?
Yeah.
And Your Honor, I did speak with my client. We went over all of his options. He is clear that the fine will remain in place and would ask the court to continue accepting a negotiated plea. We would request, Your Honor, to waive all probation fees so that he can meet these substantial obligations, including the fine as well as paying out of pocket for the other 2 classes. So we would ask the court to waive all of his probation fees and allow him to switch to non-reporting status upon completion.
Mr. Dotis, I already explained, I'm not waiving his probation fees except for the first month. And he's going to be on active probation.
Understood, Your Honor.
So if that's still a deal breaker, then we can go to trial. I've already explained that I don't have a current address. I only have indication that he's an out-of-state resident and that he doesn't qualify for non-reporting probation.
If I could have a moment on mute just to ask Mr. Diedrich.
4 North, who do we have?
Add on position 1, Adams.
All right, thank you. Come through loud and clear. Thank you. All right. Mr. Dotis, I'm going to put Mr. Stevens on hold. This is State versus Christopher Williams Adams, 22 CR 2587B, in which he's accused of the following offenses: giving false information to an officer, failure to maintain lane or improper lane change, and reckless driving. Mr. Adams, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and Angelo Dotis, who is seated in courtroom 2, will be representing you. Mr. Dotis, how are we moving forward with Mr. Adams' case?
Your Honor, is this add-on 1?
Yes, it is.
I'm not clear if we've had a chance to speak with Mr. Adams yet.
Did you receive a plea offer?
Your Honor, we did receive a plea offer over email that we'll need to have a breakout room. If we can be placed in a breakout room, can you handle that while I handle this? Sure. Attorney McLean will handle that while I finish up with Mr. Diedrich. We are ready for it.
Release Arnold. Come on.
All right, and do we have Allman at 4 North? Mr. Dotis, have you had a chance to speak to Mr. Allman, Dale Allman?
I need to communicate to him the latest variation, and that should be brief. If we could do that, we might be able to handle that today, Your Honor.
Okay, so Mr. Jordan, 4 North, and Mr. McLean, who's on Mr. Dotis's laptop, is going to be in a breakout. And where's Mr. Allman?
I haven't retrieved that person yet because I didn't know he was on this floor.
All right. All right, Mr. Adams, yes, Mr. McLean?
If I might mention, on our DVBW calendar, there is a Mr. Brown who's on Zoom. And I do need to speak to him before we go forward, if he'd like to hear from our office.
Okay, I'll make a note of that. Thank you.
Thank you.
Yeah.
Your Honor, if we could finish up with Mr. Diedrich, position 9, this will be a negotiated plea.
All right. For North, you're going to go into a breakout with Mr. McLean. Mr. Jordan, again, the breakout will be with 4 North and the Zoom panel, PD Angelo Dotis. Okay. Going back to Mr. Stephen Dedrick or Dedrick Stephen, this is going to be a negotiated plea. Okay. Mr. Stevens has already been advised of his rights and he's been sworn. You may continue, Mr. Pellin. Mr.
Yes, Your
Pellin,
Honor.
on
Yeah,
position
I'm-
9 and position 32.
Yes, Your Honor. I was just trying to pull up the time served. Okay. Your Honor, in this matter, state's recommendation is 12 months to serve 30 days, credit for time served 15. I'm sorry, that's the wrong sentence. Here we go. 12 months probated, balance probated. That's why I didn't write down the time served. $300 fine, Operation 21 course, and the anti-theft course, and then a stay away order from 950 West Peachtree Street, Northwest, Atlanta. That's a Publix location, Your Honor.
All right. Mr. Dotis?
Yes, Your Honor, he has been in custody, so we would ask him to for the plea offer to read serve 32 days, credit for time served of 16 days, so that he gets the credit for this towards his sentence. But he understands all of the conditions, and we do stipulate to the factual basis, venue and ID for the purpose of the plea.
I guess the state doesn't object to that, but if we're recommending 12 months probated, I don't understand what the advantage of that
It would
is.
be, his probation would end a month earlier, so.
I understand.
Yeah, if he's paying, you know.
The state doesn't object to that, Your Honor.
So credit for how many days, Mr. Dotis?
Your Honor, we'd ask to serve 32 days, credit for 16 days would make this a time served.
Okay. 12 months to serve 32 days, credit for time served 16 days, balance probated with the fine and the programs. Is that correct?
That's correct, Your Honor.
Okay. And the bench warrant matter on position 32 would then be null pros. Would that be correct, Mr. Pella?
That's correct, Your Honor.
Okay. Mr. Stephen Dedrick or Mr. Dedrick Stephen, have you consumed any medication or alcohol recently?
Well.
And Mr. Dotis, you stipulate to the factual basis, venue and ID, yes?
Yes, Your Honor.
Okay. Mr. Stevens, are you satisfied with your attorney?
Yeah.
And has anyone forced you, induced you to take a plea today?
No.
I can't hear you.
No.
Thank you. Mr. Stevens, if you decide to plead guilty today, you'll be on active probation. While you're on active probation, you will need to complete all these requirements, and then you will start paying probation fees after 1 month. Do you understand that?
Yes.
All right. And you also have to, I'm sure you've spoken to your attorney. In order for me to accept the plea, you would have to willingly and knowingly give up your constitutional right to a trial, to lose the opportunity to go back to court, to challenge the evidence and the witnesses who may be brought against you, to confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you certain you are prepared to give up these rights?
Yes.
How do you plead to 1 count of obstruction of a law enforcement officer and 1 count of theft by shoplifting?
Guilty.
I'll accept your guilty plea to both these charges. Your sentence will run concurrent. It's 12 months to serve 32 days, credit for time served, 16 days. If you have no other cases holding you at the jail, you will report, then you'll be released within 24 hours, and you must report to the probation office at 132 Mitchell Street in downtown Atlanta. Within 30 days of being released, You must update the court's records as well as probation records with your new mailing address. We only have a Wisconsin address. If you're a resident of Atlanta, we need a new mailing address for you. Do you understand, sir?
Yes.
So let them know.
And that's going to be a condition of probation. So you make sure you do that. You also need to pay a $300 fine. You need to complete the Operation 21. You need to complete an anti-theft class, and you must stay away from the Publix located at 950 West Peachtree Street in downtown Atlanta, which means that you're supposed to stay 200 yards away. That's the length of 2 football fields from that location. Do you understand?
Yes.
Your probation fees are waived for the first month, and then after that, you will be on active probation where you'll be paying probation fees from month 2 onwards. Thank you.
Next,
The warrant is null pros.
is he done?
He's done.
Yes, he's done.
Position 19, Mr. Knight.
Mr. McLean, is that your client, Mr. Dotis?
Your Honor, I'm gonna handle Mr. Knight while Mr. McLean's out. I just need 1 second to speak with Mr. Knight.
South Annex, is that a 11 o'clock calendar matter, or is it the 9 o'clock calendar matter? South Annex.
11 o'clock.
All right, please hold.
And Your Honor, if this should be a negotiated plea for position 19, if I could just have someone confirm his jail time. Attorney McLean does have my laptop, and I want to make sure that it is a time secure.
All right. My jailing screens are not, okay. And in this particular case, he was charged with criminal trespass from June of 2021. I had 14 days on the bench. Was he arrested on a bench warrant? Or is this yeah, June 2021. I have 14 days, Mr. Dotis.
Thank you, Your Honor. That's what I believe I had written down, but again, just wanted to confirm. So we are prepared to go forward.
Okay. This is State versus Elgin Knight, 22 CR 1831B. Mr. Knight is accused of criminal trespass from June 29th, 2021. Mr. Knight, you've been advised of your right to remain silent, and your attorney is Mr. Angelo Dotis. Okay, this is going to be a negotiated plea hearing. So, Mr. Knight, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Okay, Ms. Allen, looks like it's 12 months. You've got to serve 28 days, credit for time served 14 days. Would that be correct?
Yes, Your Honor.
All right. And what's the rest of the plea?
Balance is suspended, stay away from the location, and no further contact. With the victim in this case, it's Cynthia Wilson, common spelling. The location is 1845 Idlewood Drive in East Point.
Is that a residence?
It is.
Okay. So it's balance suspended with regards to Ms. Wilson, the no contact provision will be ineffective since it's balance suspended. And the stay away will be noticed to Mr. Knight that he has to stay away from that location or risk the chance of being rearrested and charged again with trespass.
Thank you.
Okay, so Mr. Dotis, are those the terms to which your client has agreed?
Yes, Your Honor, and he understands that that is an address he cannot return to, and he tells me he has no reason to return there. So we would just ask the court to accept the negotiated plea and do stipulate to the 3 elements.
Mr. Knight, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the explanations of your counsel?
Yes, ma'am.
Are you satisfied with your attorney?
Very.
Is anyone forcing you to take a plea offer today?
No, ma'am.
And have you understood that if I accept your plea, that you will be giving up your right to a trial, to
Yes,
go
ma'am.
to go back to court and confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt?
Yes, I understand.
And are you freely and willingly giving up this rights?
Yes, I am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended. You have to stay away from 1845 Idlewood Drive in East Point, Georgia. If you return to that location or seen within 200 yards, or well, if you trespass on that property again, then the state can bring a new charge of criminal trespass against you.
I understand.
Thank you.
Mr. Knight.
Thank you. Thank you.
Deputy Francois, who's next?
That's it for courtroom 2, Judge.
All right, South Annex is a 11 o'clock matter, so we will address our DB set aside. I know Mr. McLean is talking to the add-on cases. So
I'm here.
I don't have my laptop, Your Honor, and I have no information on the bench warrant calendar, so we'd have to hold for Attorney McLean.
Okay.
I do have a quick announcement for position number 20. They're located at Grady.
Okay, thank you.
And Your Honor, for position 20, that was supposed to be a negotiated plea that was time served. So since it needs to be reset, we'd ask for a reset to Tuesday's calendar.
Miss Champion, what's the Tuesday's calendar look like?
It can be added on to Tuesday.
All right, thank you. It'll be reset to September 12th at 9 a.m. All right, while we are waiting for Mr. McLean, I'm just going to go over the calendar just to see what's going on. On the add-on calendar, position 1, Adams is still holding. Position 2, Allman. Position 2 and 3, Allman is still holding. Position 4, Rhodes was a plea. All right, on the SAP calendar, position number 1, Boswell was a plea. Position 2 is Nullcroft. Position 3, Harry Brown. Harry Brown. Mr. Dotis, I don't believe you've had a chance to speak to him.
No, Your Honor, I haven't heard on if jail staff was able to locate him. This is another case where it would be likely a time served offer, so.
I'm sorry, Mr. Dotis, please complete the sentence.
Sorry, Your Honor, this was an offer that this is his only hold, and I believe he would have been released if able to take a plea. It's just a criminal trespass charge, so hopefully jail staff can locate him and we won't have to reset him.
I'm going to reset him to September 12th, unless Ms. Champion chimes in and says we are absolutely full.
Thank you, Your Honor.
Position 4, Regina Curry was a plea. Position 5 is null pros. Position 6 is further notice for jail jury. Position 7, Clyde Davis is a plea. Position 8 is reset to September 14th. That's Mario Dawson. He needs a C3 appointment counsel. Position 9, Stephen Dedrick is a plea. And position 32 is null pros. Position 10, Justin Farrell. Position number 10 is null pros. Position 11 is a plea. Position 22, Gresham is a plea. 13 is a plea. 14 is null pros. 15, Andre Hill. That's another case, Mr. Dotis, of yours?
I haven't, this is Flood, I haven't been down to 3 South yet because I'm still looking for one other inmate up here.
All right.
I gotta go down to 3 South when I'm done up here.
All right, so Mr. Hill may still be possibly found.
Your Honor, we still have.
5 North, I'm sorry, 5 North, who, yes, sir, what is going on?
Your competency calendar.
Yeah, I'm going to be addressing that soon. I'm just going over the SAP calendar. Thank you.
Alright. And Mr. Almond, he's on 3 South.
Who's Altman? Is that the competency matter also?
No, he's add on positions 2 and 3. He's,
Okay.
3 South 500.
All right, we'll be addressing him soon. Thank you. Position 15 and 16.
Excuse me, Judge Law. For position number 3, Mr. Brown Harry, he's supposed to be on 5 North. Will, you got him?
5 North.
Give me 1 second. Let me see if he's here. And you said, what's his name again?
Harry Brown.
Joe Brown.
All right. Give me 1 second.
Thank you.
Okay, so I'm putting Harry, position number 3 as a possibility also. Okay. Mr. Dotis, looks like your clients are coming out of the woodwork now. Okay, so moving back to the calendar announcements to position 15 where I last left off. So Andre Hill, 15 and 16 is possible. 17, Jackson was a plea. 18, John Kitchen. That's another one unable to locate. Any announcement, Mr. Dotis or Deputy Francois?
Francois, do you know 18?
I tried searching for him on 4 South where they say he's located. He wasn't there this morning. I just called classification. And they stated that he was housed there, but I didn't see any information of him being on that housing unit.
Mr. Dotis, looks like this is also would have been a 30 days, a plea that would let him out today or within 24 hours. So I'll reset this to September 12th.
Thank you, Your Honor.
And hopefully you'll be able to talk to him by then.
Understood.
Your Honor, add on 1 or 2 right in front of you.
All right, thank you, sir. Position 19, Elgin Knight was a plea. Lionel Nephew, position 20 is reset to September 12th. Position 21 was a plea, 22 was null cross, 23 was a plea. 24, Perry, Dontavius Perry. Mr. McLean, did we address that as a plea?
That was Ms. McLeod's case, Your Honor, and that is the pending transfer to the DA. I believe you reset it.
Yeah, this is pending transfer, so I reset it to September 14th. And yeah, that was what it was. Thank you. Position 25, Samples was a plea. 26 is null cross. 27, Brandon Smith was a plea. 28 was a plea. 29, Joshua Smith is reset to September 14th. The plea offer was rejected. Rejected by the court, that is, based on the statements by the alleged victim. Position.
I think that was position 30, Your Honor. Position 29 was a plea. Position 30, Danny Solano.
No, Mr. Smith was the plea about credit for time served. That's almost a year, but that plea offer was rejected, and we're going to assist the victim in completing her TPO process and look at all the other issues. Mr. McLean requested a reset.
Okay, so position 30, Danny Solano.
Yeah, Danny Solano was a plea.
Okay.
And position 31 is null crossed.
Okay, thank you.
All right, that was a negotiated plea and where he has to stay away from Hemingway Lane and have no contact with Callan Guerra. Position 31 is null pros. Position 32 is null pros. Position 33, Michael Sutton was a plea. 34 is null pros. 35 is a waiver of arraignment and further notice jail jury. Position 36, Berthenia Thurman is Mr. McLean is going
She was,
to, Mr. McLean, you're going to submit a waiver of arraignment for Berthenia Thurman?
Your Honor, she was released.
Oh, she was? Okay. So
Right.
that's going to be further notice for trial. And position 37, Del Monte Wiggins is a 1-week reset to September 14th. All right. Let me address Mr. Allman, position 2 and 3. Mr. McLean, have you had a chance to speak to Mr. Allman?
No, Your Honor, I was going to do a breakout with him. I was going to ask the state too in a chat. I saw the new offer on him, and if there are no conditions in the probation, would the state be okay with a balance suspended? I think that might help. On Mr. Adams, I had a good discussion with him, and I think we're ready to go forward on that.
All right. So Miss Allen, you can go ahead. Oh, Mr. Pellin, I'm not sure who's the prosecutor for the Almond case. Y'all can communicate via email. Position 1 is Christopher Adams. And Mr. Adams, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean, who is appearing under the Zoom pad. He's got a bunch of books behind him on that thing. So, all right. And so, Mr. Adams, you've been advised of your right to remain silent. And may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. All right. Where is Miss Allen? What is the plea offer for Mr. Adams?
Their offer in this case, Your Honor, is a 12 months on probation, serve 40 days, credit for the 38 he's already served, a risk and reduction class, or payment of a $300 fine.
Mr. McLean,
Yeah, there was a little bit of, Your Honor, there was a little bit of audio breakup for me.
I
Was
can say it again.
Was that RR or
Yes.
RR and? I see. Mr. Adams, do you understand that the state is offering you that you should either do a risk reduction course or you should pay a $300 fine? Which do you think is more to your benefit, and which do you think is more to the benefit of the case?
Risk reduction, I think it'd be overall,
Okay.
just for the, rehabilitation.
You have to find the provider, a qualified provider, and prove that you completed the course. You have to pay for it yourself. You know all that.
Yes, sir.
Very good.
all right.
Thank
And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Adams, have you consumed any medication or alcohol?
No, ma'am, I have not, Your Honor.
And have you understood the explanation of the attorney and what's been happening so far?
Yes, ma'am, I do.
Are you satisfied with your counsel?
Yes, very much so.
And is anyone forcing you, inducing you to take this plea today?
No, ma'am.
And has it been explained that if you decide to plead guilty to giving false information to an officer, failure to maintain lane, and reckless driving, that you will be giving up your right to a trial to challenge these charges in a court of law? You will
Yes,
not have the assistance of counsel to challenge the evidence, the witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am, Your Honor.
How do you plead to these 3 charges?
Guilty, Your Honor.
Thank you. Your sentence is 12 months to serve 40 days, credit for time served 38 days. The remainder of the time you'll be on probation. You will report to probation at 132 Mitchell Street in downtown Atlanta. And that will be next Thursday. That is if you're released within the next 24 hours. Does he have any other holds?
He does, Your Honor. Pinellas County, which is St. Petersburg, Florida, has a matter for him. So he'll deal with that. And any financial break the court could see clear to give him would be super. He won't be having any substantial money for a while. He does intend to stay in touch with PAD as soon as he gets back to Atlanta.
All right. When he returns to Atlanta, and he needs to report to probation immediately on any business day, which is a Monday, Tuesday, or Thursday. And I will waive his probation fees for the first 2 months. He has to attend and complete a risk reduction program. Once he's completed and provides the certificate to his probation officer, his probation will be non-reporting.
Sounds very good. Thank you.
All right, so Mr. Dotis, you can get back to me about Mr. Allman.
I can go forward with Mr. Allman, Your Honor.
You're going forward with Mr. Allman?
I do need to make sure that he understands. I was asking whether the state could live with suspended instead of probation if there aren't any conditions to monitor.
After this one, Mr. McLean, you will be in a breakout with Spence Brown.
Very good. I had to, in all candor to the court and to the prosecutor, I had to admit in our conversation before court this morning, I can't document Mr. Allman's disabilities, but I have seen them because I watched him walk up the stairway to the visitation booth twice in the last 2 weeks. And he does have a lot of trouble getting around.
Oh dear. Okay. Is Mr. Allman the gentleman at South Annex? All right.
There we go.
So, Mr. McLean, are we ready to proceed with Mr. Allman?
I believe we are, Your Honor.
All right, let me go ahead and pull that 2 cases up. Mr. Dale Robin Allman, located at South Annex. Mr. Allman, can you hear me?
This is Mr. Reed. This is Walker Reed at South Annex.
That's not Mr. Allman.
Where's Mr. Allman? I thought he's at 3 South. 3 South?
Where did he go? Let's see.
Okay, South Annex is a competency matter. Mr. Dotis, I'm going to put you in a breakout with Spence Brown.
Right, this is McLean using Dotis' computer, right?
Mr. Brown, you're going to see a message on your screen to join a breakout room. And Mr. Jordan, if you could please place PD Angelo Dotis, AKA Michael McLean, into a breakout room, please. Thank you.
And Mr. McLean, as far as Mr. Allman is concerned, when he is available, we don't have a problem with non-reporting.
Oh, is that Mr. Allman at 5 North?
No, this is Mr. Harry Brown.
Mr. Harry Brown, is that your client, Mr. Dotis?
Yes, Your Honor. I do need to speak with Mr. Brown. I'm trying to think of a way to do that.
We're going to fix a way. Would you be able to go into a breakout from your current screen?
Your Honor, we are in a public location, so I want to make sure I have privacy with Mr. Brown. Let me go see if I can. We're using both of the phones for first appearance.
All right, we're stuck. 5 North. We're just going to have to wait until Mr. Dotis has his laptop back to do a breakout.
Thank you. I'll see if I can track down Mr. Howard to use his laptop if that's a possibility.
Mr. Howard's in a breakout room too.
All right. Is Derek Howard available?
He's in a breakout room with the South Annex.
Okay. So everyone's in a breakout. We're going to take a 5-minute recess and then we're going to resume with the calendar as soon as folks come on the breakout. We're going to do Mr. Brown, the DV set aside, and then Harry Brown, which is the other case on the SAP, Mr. Allman, if he's available, and then the competency calendar. Okay, who's going to be in the competency calendar with me? Ms.
We've got
Allman?
Vic-
Okay, all right. Okay, now I've got a 4-minute recess, so we'll be back in 4 minutes. Mr. Dotis, anything to report?
Unfortunately not, Your Honor. Attorney McLean is still in a breakout room, I believe. I'm trying to track down PD Howard to see if I can use his laptop, but I know he's in a breakout room for competency.
All right, well, I'm sorry. I mean,
That's okay. As soon as I'm ever vigilant. As soon as I see my opening, I'll hop on it.
all right, thank you.
Thank you, Your Honor.
Okay, I think Mr. McLean is still talking to Mr. Brown, and so we'll just be in recess until one of our attorneys are available. Thank you.
I have position number 15 and 16, Andre Hill.
I'm gonna have to wait for Attorney McLean to finish up with my laptop for a breakout room. Hopefully it's quick.
Mr. Otis, do you have your cell phone?
No, Your Honor, otherwise my cell phone is in my car. I can't bring it into the jail.
Understood. Okay. All right. Deputy at 3 South, Mr. Hill will need to talk to his attorney, Mr. Dotis, as soon as the device is available for him to have a private conversation with his client.
Okay. Can we do Dale Almond? Can we do him next, Danny?
Who's the other one?
Dale Almond, positions 2 and 3 on the add-on calendar.
Has he spoken to Mr. McLean?
I'm not sure. Hold on, let me ask.
Mr. McLean's on a laptop and he's supposed to be talking to Mr. Almond.
How you doing today?
Fine, thank you.
He said that he did speak to Mr. McLean. He's good on that part.
All right. As soon as Mr. McLean pops up on the screen, we'll be able to address it, okay?
Okay.
Thank you. Please mute your screen, please. Oh, it looks like it's a medical facility. Could you stop the video also? Deputy, we can stop the video at 3 South until Mr. McLean appears. Thank you. All right, Mr. McLean, which case are you ready to address first?
Either one, Your Honor. I think what I should do is run across the hallway and give Mr. Dotis his laptop back, because right now I don't need it, and that way he's free to use it if he needs it.
All right, underlay.
Thank you.
While he's headed back, if Mr. Jordan could put my laptop in the breakout room with, I think, 3 South or 5 North, whoever's waiting, I don't know.
Okay, Mr. Jordan, if you could put, Mr. McLean, go ahead and bring the laptop to Mr. Dotis.
Yes.
He's here.
Oh, he's in motion. Okay, there he goes. All right.
Thank you.
Mr. Jordan, please place Angelo Dotis in a breakout with 3 South.
Yeah.
I can hear you, Mr. Dotis.
Yeah.
All right. Mr. Dotis, I can put you in a breakout.
Doesn't work. I got it.
And go ahead, mute PD Angelo Dotis too. 3 South. 3 South. Deputy, you're going to get a message to go into a breakout room, please.
Okay.
Thank you. We are, while we are waiting for Mr. Dotis to complete his conference with his client, we are going to the domestic violence bench warrant case, which is State versus Spence Bernard Brown, case number 21 CR 005-958A. 3 South, you're going to get a message on your screen to join a breakout room, please. Mr. Dotis also, please make note to join the breakout. Okay. Mr. Spence Brown, you were originally charged with battery family violence on April 29th, 2019. You have a right to remain silent about the facts of the case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean will be representing you. It appears that
she told somebody else.
it appears, Mr. Brown, that you had a prior bench warrant on January 12th, 2022, and that you made a new bond on March 8th, 2022. You had another court appearance where you failed to appear and your bond was forfeited on August 3rd, 2023. You've requested that that bond forfeiture be set aside. All right, Mr. McLean, you may proceed.
Your Honor, Mr. Brown is a veteran who was in Desert Storm, and he currently has stage 5 cancer in one part of his body, congestive heart failure, diabetes, and hypertension. He went to a court session and began to feel dizzy, lightheaded, and had to go. He didn't have anybody with him. Sometimes when these conditions come on with the lightheadedness, he needed to leave, and they've marked him. I believe what I heard from him was that he was actually physically there at the court session, but left early in a way where they marked him absent. He has limited income. It's only through the VA. He's 100% disabled. Since he did physically make that court session, we have his word for that, but I realize it was not marked down that way. He will make his further court dates. We discussed how he knows what the courthouse is. He knows where Judge Ross' courtroom is, and shouldn't have any problem with that. This is a 2019 case. He adamantly denies the facts as alleged against him and looks forward to proving that in court. We would ask the court to consider setting aside the BBBW in this situation.
All right, so what you're stating is that Mr. Brown allegedly appeared in court on July 31st of this year at 9 a.m., but then left without notifying the court.
I'm not sure what date we were talking about, but he says, I showed up in court and I was about to fall out. I got dizzy. I didn't have anybody with me and I ended up leaving early. So if that was, is that the date we're talking about, Mr. Brown?
Yes, that was after my name was called.
I understand.
And then shortly after that, I think I was supposed to speak with the prosecutor, or in the next room. It was someone I was supposed to speak to, but before I got to that point is when I had my episode. And I had to go out. I didn't know if I was gonna vomit or whatnot. I wasn't sure. And sometime I pass out. I never know what's gonna happen.
So when you went to that court session, you didn't have any problem getting your mail notice as to how to get there, right?
Is Mr. Brown testifying now? Should I place him under oath?
Yes, Your Honor.
Mr. Brown, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you.
Your Honor.
Next question, Mr. McLean.
So even though I'm your counsel, I shouldn't ask you a leading question. Tell me whether or not you have any problem getting court notices these days, please.
That was for me?
Yes, that's for you. Do you have any problem getting your mail?
No, sir.
Do they have your email, or which way do you find out when court is?
Email. That's how I got the email. Yes, sir.
And do you recall that I just discussed with you the idea of the VA can provide an advocate who can come with you?
Yes, sir.
Okay. Your Honor, I believe because he's 100% disabled, I believe that either the VA itself or a veterans organization can perhaps provide an advocate to come with him to court next time to help out on it.
Mr. Pellin?
Yes, Your Honor. May I ask Mr. Brown a few questions?
Yes, you may.
Mr. Brown, do you recall what happened the day that you went and you were sick? What kind of court hearing it was?
Yes,
said they
sir.
called your
It
name.
was,
Or I saw you reaching for a piece of paper. Do you recall the
yeah, I'm
specific
trying
date?
It was the 31st, July 31st.
Okay. And then I'd also, we're able to post a $2,400 surety bond initially, correct? At least for this most recent matter.
I'm not sure what that means.
So you currently have a bond and you're asking that that bond not be forfeited, correct?
Correct.
And a surety bond is a type of bond where you do not put down the entire amount, but you put down a percentage. That's the type of bond you have in this matter.
Okay, yes, sir.
Did you put down a percentage?
Yes, sir.
Okay, no further questions, Your Honor.
All right. Mr. McLean, anything else?
Nothing further, Your Honor.
I would make a brief argument, Your Honor.
You may, sir.
The defendant showed up on 7/31. He was not FTA'd for 7/31. He was FTA'd for not showing up to trial the next day.
I noticed that.
So I'm having a hard time reconciling defense counsel statement of he can't afford a surety, but he did afford a surety, and he does come to court, but I guess he didn't have adequate notice that he was going to court the next day. That just doesn't
because
seem
I left
credible.
early.
Mr. Brown, this is closing statements. You don't get to interject or interrupt. Thank you.
Sorry.
I just don't find the defendant's statements credible, Your Honor. And I don't find it credible that no one noticed that he was going out sick, that he couldn't notify the deputy on his way out, hey, I'm having a medical issue, I'm leaving. I don't find that credible. And to defense counsel's point that it's a 2019 case, it would have been resolved much faster if the defendant hadn't FTA'd twice. So I don't see how that should count in his favor.
All right.
Your Honor, if there's any desire in the court's part to have documentation of the medical conditions I mentioned, the stage 5 cancer, the congestive heart failure, the diabetes, and the hypertension, we'd be glad to provide that as soon as possible.
I don't know if state's recommendation would change with that documentation, but it's certainly not going to change without it.
Mr. McLean, I'm still not certain what you're telling me. Did he have a medical excuse why he didn't show up on August 1st for his jury trial?
I believe there would be a medical excuse if we looked at the documentation of his conditions, which back up that he basically got lightheaded, dizzy, and almost fell out. But the dates, he was there one day, and if they were telling him to be in court the next day, I'm not real clear that he understood that the next day was his trial.
I'd like to clarify defense counsel's assertion. Are you asserting that you have medical documentation of diagnoses or medical documentation that he was sick that day and experienced symptoms that day?
Diagnoses.
Okay, so you don't have medical documentation that he was sick that day.
I don't have anything about him going to the doctor that day.
All right, what are you seeking, Mr. Pellet?
I'd ask the court to surrender the bond.
All right. Mr. McLean, your closing statement.
Your Honor, he is 100% disabled and his only income is from VA. It is in a range which may make him eligible or ineligible. It probably will make him ineligible for a public defender. However, it's going to be tough for him to hire private counsel, and I've encouraged him to look into that. The state bar does have a referral service in which they can consult with private counsel if he's indeed ineligible for our scale. I think our scale is a bit out of date. But I would ask the court to consider giving him a buy on this situation because of the medical situation, both the acute medical situation that day that he has described and the ongoing medical situation that we can document with proof in a documentary way.
Mr. Brown, this is not your first time in this situation. You have failed to appear in the past where you had to go ahead and issue a new bond. Do you recall? Mr. Spence,
Yes,
do
ma'am.
you recall?
Yes.
So you showing up in court and feeling ill and leaving on your own is clearly your choice. But Mr. Brown, you're being summoned to court and leaving without notifying the court or getting court permission is a violation. You've been in the military. If you're under a military order to appear somewhere, you need to appear. End of story. You had absolutely no right to leave that courtroom. If you were ill, you were required by law to get the permission of the judge to leave the courtroom. And I understand it is a medical situation, but what is concerning is that after you left, you never made any steps afterwards to come back to court until your bond was forfeited to let the court know, oh, I had to leave. So I don't have an explanation of why there was a time gap. There's been absolutely no explanation. I'm going to deny your bond forfeiture because of these reasons. I can understand if you had to medically leave the courtroom, but what I don't understand is why weren't you diligent about coming back and telling the court or the court staff, I'm sorry, I had to leave. I was very ill. I need to make right with the situation. That's the part I do not understand. It's almost like you waited to see what would happen. And now you're back to square one. Like I said, this is not your first time. I'm going to amend your bond to a $5,000 signature bond through pretrial services. You're going to go to the Fulton County Intake Division. You're going to be booked in on this bench warrant, and then you're going to be released on a signature bond through pretrial. And you're going to report to pretrial every month until your next court date. And if you don't report to the next court date with an advocate or with an attorney or with someone who could help you out while you're in the courtroom, that is on you. Do you understand, sir?
Yes, Your Honor.
Your motion to set for the bond forfeiture is denied. Instead, you will report to the Fulton County Jail Today is Thursday. You will report by 5 p.m. tomorrow, which is September 8th, 2023. Your bond is amended to a $5,000 signature bond to pretrial. You'll be interviewed by pretrial services, and then you will be reporting to pretrial once a month until you receive your, and when you get your next court date, you'll report to court in accordance with either a companion or an advocate or an attorney. That's entirely up to you.
Understood, Your Honor. Now, Mr. Brown, you're local, so being at the jail by 5 p.m. tomorrow will not be a problem for you, correct?
No problem.
I would recommend you wait till 6 p.m. today when Mr. McLean sends me the proposed order so that we can amend your bond and have it sent to the jail. Otherwise, you'll be in jail a lot longer than expected.
Your Honor, I'd like to clarify with the court, this charge is a family violence charge, and it's my understanding that family violence charges are excluded from unsecured judicial release. I don't know.
This is not a UJR. This is
that's
not a
what I did.
UJR. Yeah, this is
thank you,
this is a signature bond for pretrial. And if he violates that signature bond by not reporting to court or not reporting to pretrial or getting arrested again, it converts to a surety bond.
Okay, thank you, Your Honor.
All right, Mr. McLean, Mr. Brown, you have your standing instructions. And Mr. McLean, if you will submit a proposed order, that would be very helpful. And we can get that to the jail as soon as possible.
Very good, Your Honor. I will be going from this location at Rice Street to downtown to get that done. Even the copier and scanner we have is totally dead over here.
All right, thank you. Mr. Davis, are you ready to address position 15 and 16?
Your Honor, I'm ready on 15 and 16. I was asking for a breakout room for position 3. I know 5 North is ready. If you'd like me to take one now and go back into a breakout room, or do a breakout room now, whatever's easiest.
Let's address Mr. Andre Hill first. This is case 21 CR 003683J. Mr. Andre Hill is accused of theft by shoplifting from April 22nd, 2020. He has a bench warrant case 23 FTA 773 from May 10th, 2020 of this year. Mr. Hill, you have a right to remain silent about the facts of the case. Anything you choose to say about the facts, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Angelo Dotis. This is going to be a negotiated plea hearing. Is that correct, Mr. Dotis?
Yes, Your Honor.
All right, Mr. Hill, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Mr. Pellant, do you have the plea offer from Mr. Hill?
I do, Your Honor. It's 12 months to serve 46 days, credit for time served 23 days, balance suspended, a stay away order from 680 Ponce de Leon, Atlanta, which is a CVS location.
All right, thank you. Mr. Dotis, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor. My client accepts the terms and is clear on the stay away location, and we do stipulate to the 3 elements for the purpose of this plea.
Thank you. 3 South, please unmute.
Yes.
Mr. Hill, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
I have.
Are you satisfied with your attorney?
I am.
And has anyone forced you, induced you to take this plea?
No, ma'am.
Are you willing to give up your right to a trial, to go back to court, confront your accuser, challenge the evidence and witnesses brought against you, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to waive these rights?
I am.
How do you plead to 1 count of theft by shoplifting?
I plead guilty.
Your sentence is 12 months to serve 30 days, credit for time served 23 days. The balance is suspended. If you have no other cases holding you, you're, all right, then you should be released within 24 hours. Mr. Hill, you cannot return to the CVS store on Ponce de Leon where this incident occurred. If you are seen anywhere near or inside that store, well, you and I get to do this all over again.
You won't have to say no more.
Thank you.
Thank you.
Position 16 will be null crossed. Thank you, Mr. Hill. Mr. Dotis, you'll be in a breakout with whom again?
5 North, Your Honor.
5 North.
And for Mr. Joe Brown, position 3.
I thought it was Harry Brown.
Harry Joe Brown. Your Honor, I was going by his middle name. My apologies.
That's okay. You're right. It's Harry Joe Brown. Okay. Mr. Jordan, if we could place 5 North and Angelo Dotis in a breakup, please. 3 South, who do we have, please?
Hello.
Add on 2 and 3, Mr. Dale Almond.
All right. Mr. McLean, have you spoken to Mr. Almond?
I've spoken to him twice in the last couple of weeks, Your Honor. I think we can, I might have to actually ask to make this non-negotiated, depending on whether the state agrees with me, that we could, if there are no conditions in the probation, so perhaps it would be okay. Perhaps
All right.
the state could live with a balance suspended.
I'm going to deem this to be a non-negotiated hearing. Mr. Almond, can you hear me? My name is Judge Law. Okay. We are addressing 2 of your cases, and they are as follows. One is a bench warrant matter, and that is case 23 FTA 734. The second case is 21 CR 7773C. And in that particular case, you are charged with theft by taking and criminal trespass causing damage to property from a December 18th, 2021 incident. Mr. Almond, you have a right to remain silent. Anything you choose to say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. This is going to be a non-negotiated hearing. So is it going to be Ms. Allen or Mr. Pellin?
It's me, Your Honor.
All right. Ms. Allen, with regards to the theft by taking and criminal trespass, what's the state's offer?
The offer we conveyed was a 12-month probation, 12-month sentence, served 30 days with credit for time served at this point, and the balance probated, stay away from the incident location, and we would null pros the failure to appear case.
All right. And do you have any particular reasons you'd like to put on the record for this particular plea offer, or shall I move on?
Well, Your Honor, the last arrest for this gentleman was in fact in December of 2021. The failure to appear was in this year. It was June 21st of 2023. And he has multiple failure to appears in his criminal history. This is also an incident where during an argument or an assumption about someone stealing his property, he went into the home of another person and damaged their property. So he was arrested for damage to property, I believe.
All right. And the jail screen shows that he's been in custody for a total of 46 days, which includes the time that he served on the bench warrant.
Right. So he would be receiving a time served.
Okay.
We'd not be requesting any further time out of this gentleman.
Thank you. Mr. McLean, do you have a response?
Just Your Honor, that if there are no conditions other than the stay away, even a balance suspended could accommodate his promise to stay away during the next 12 months or 11 and a half months or whatever it works out to.
I can amend it to non-reporting probation except for the first visit, and then he'll be on non-reporting probation for the remainder of the time. Would that be acceptable to your client?
I believe it would. Would that obligate him to pay the first month of probation, or could the court waive that fee?
I will waive that.
That's super, Your Honor, because then he could just simply report in person. Now, he physically does have trouble getting around. Mr. Almond, I saw how you walked in the jail. Can you get to 132 Mitchell Street one time?
Sir?
Can you get to 132 Mitchell Street one time in person?
Can you go to 132 Mitchell Street in person?
Well, I mean, hit by a car, man. You got that movement like that.
I'm not understanding. There's a bad.
He said he was hit by a car, so he doesn't have that movement like he used to.
Right, I saw how he moved. So is there anybody that can get you to 132 Mitchell Street, report in person one time for probation?
Sir,
Can anybody get you to 132 McKee for probation? He said no.
Well, well,
And Your Honor, when I review the facts in this case, I was mistaken. This is actually an incident where the defendant was seen obviously in 2021, but he just failed to appear in this case this year. He was seen entering into people's cars. He then was reported to be in possession of a wallet of one of the victims who came and responded. And the Apple GPS key fob on her wallet was tracking the defendant. He was found and he admitted that he had the wallet in his possession after initially denying it, but was then in a position where the wallet started to make sounds because of the GPS that was inside of it. And at that point, he said, I just don't want to get in trouble. And he was arrested, and the people whose car he broke into were given back their wallet and keys.
right. I'm just trying to figure out a way to get him over to 132 Mitchell. I can ask our investigators if we can set up an appointment to do a ride for him.
Okay, thank you, Mr. McLean. Mr. Almond, can you hear me, sir? What we're doing right now is to determine whether you want to plead guilty to theft by taking from this incident involving a wallet. Do you understand? And if you decide to plead guilty, you will have to report to the probation office one time only next Thursday. And we need to make sure that you can get to the probation office. Otherwise, I'm going to reset the case for you to, for me to be comfortable that you can report to probation. So you need to tell me, how are you going to get to the probation office if you plead guilty today?
man, where that came back, just a little guess. But time, man, when they had with it, I understand you do the job.
I just need an answer to one question. How will you get yourself to the probation office? You decide, sir.
This meeting is being recorded.
Your Honor, I'm not getting a response out of him either.
Okay.
I'm thinking that if I can get hold of an investigator, I'm going to find out from people whether he's already been involved in PAD or not, but somehow we're going to find him a ride, Your Honor.
I'm going to take this plea, and it's going to be up to Mr. Almond as an adult to decide how he's going to report to probation by the deadline. All right. Mr. Almond? Please unmute. Yes, sir. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right. Mr. Almond, have you consumed any medication or alcohol recently?
No.
And have you understood your attorney?
Yes, ma'am. Yes, ma'am.
And do you realize that you're charged with theft by taking and criminal trespass causing damage to property?
Yes, ma'am.
I'm sorry?
Yes, I.
All right. Is anyone forcing you to plead guilty to these charges today?
No.
And if you decide to plead guilty, you would have to give up your right to have a trial, to confront your accuser, challenge the evidence and witnesses brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking and one count of trespass causing damage? Mr. Almond, how do you plead to one count of theft by taking and one count of theft of trespass causing damage to property?
I plead guilty.
Repeat, please.
I plead guilty.
Your sentence is going to be 12 months to serve 40 days, credit for time served 38 days. Your time at the Fulton County Jail is concluded. You will be on probation in order for the rest of the time, which will be 11 months. I'm going to put you on non-reporting probation but except for the first visit. You must report to probation this month. This is the month of September. Your last date to report to probation this month will be September 28th, 2023. I'm giving you over 3 weeks to make sure that you make arrangements to report to probation by September 28th before 3 p.m. Do you understand, Mr. Almond? If you fail to report to probation by September 28th before 3 p.m., probation has the right to file a revocation and have you brought back to jail. The probation office is located at 132 Mitchell Street in downtown Atlanta. Mr. McLean, I am going to leave the thankless job with you to make sure that you assist Mr. Almond to comply with at least his first time visit to probation, because after that it will be non-reporting. So it'll be a shame if he doesn't comply.
Thank you, Your Honor. Now, I noticed from his background, he's over at ACDC now, it looks like.
He's at 3 South.
Oh. That's 3 South here. Okay, gotcha. I'm gonna come down, as soon as court's over with, I'm going to come visit you, Mr. Almond.
All right, that concludes position 2 on the add-on. Position 3 on the add-on will be null crossed. Thank you.
And Your Honor, we're ready on position 3.
Okay. 3 South, thank you very much. You may mute. Thank you. Mr. Dotis, your client is at 5 North, and this is State versus Harry Joe Brown, accused of criminal trespass in case number 23 CR 005210Y. Mr. Brown, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have the right to an attorney, and representing you is Mr. Dotis. Mr. Dotis, how are we proceeding with this case?
Your Honor, I believe that this will be a negotiated plea. There was an issue with
I'm sorry, Mr. Dotis, you're not coming through very clearly. 5 North, please mute your screen. Thank you. All right, let's try that again, Mr. Dotis.
Thank you, Your Honor. I believe that this will be a negotiated plea after further discussion regarding jail time. We would also request a one-time sheriff's escort so that Mr. Brown can retrieve his property.
And Your Honor, the state would actually object to that provision, but not to the time.
All right, so tell me again, Mr. Dotis, it'll be 12 months to serve 30 days, credit for time served 15 days. Would that be correct?
Your Honor, it should be served 28 days, credit for 14 days.
All right. And then why does he need to return to 50 Valley Road?
Your Honor, he thought that he had a lease for that property, and it turned out, it appears that it was a fraudulent lease. He had moved his property into that location. He's clear that is not the case after an interaction with what turned out to be the actual property owners. He doesn't want to return to that address in that or anything beyond just getting and picking up the property that was left at that address.
Is this a single family home, or is this an apartment complex with a leasing office?
It's a single family home, Your Honor. And I can give a brief statement of facts if Your Honor would like.
Yeah, go ahead, Mr. Pellin.
So, Your Honor, in this matter, the defendant occupied a vacant home that was for sale. The defendant actually took the for sale sign down and moved into the apartment. When officers arrived, he showed them a lease agreement showing that he leased the home for $17,000. However, the listed real estate agent on the lease does not exist, and he could not show officers or the homeowner any proof that he ever spent that amount of money. Defendant was advised to vacate the residence on 8/24 when he was confronted with that evidence, and on 8/25 when the homeowner and officer arrived, he was still in the home and had taped over the locks in an effort to keep the homeowner out. The defendant had moved a significant amount of furniture into the home. The homeowner had to incur a $7,000 cost moving that furniture out of the home, so that the belongings that he had in that residence are no longer there. So that's why the state would object specifically to the sheriff's escort. Other than that, I think the offer from the state is pretty generous.
The request for a one-time visit is denied. If there is any loss of property, Mr. Brown can go through the civil routes to seek compensation, but no.
Thank you, Your Honor. And I went over his civil options. This will still be a negotiated plea.
All right. Mr. Brown, if you want to proceed with this plea hearing, I'll need to place you under oath. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
Thank you. And Mr. Pellin, the terms are 12 months to serve 30 days, 28 days, correct, time to serve 14 days and to stay away. Would that be correct?
That's correct, Your Honor.
And you need him to be on probation?
I reviewed that, Your Honor. No, he doesn't have to. Well, the state would prefer non-reporting probation.
All right, it will be non-reporting probation with a first-time in-person visit.
Your Honor, we would just ask there's no conditions, so we just ask it to be found suspended.
I can do the first-time visit and then non-reporting probation.
Understood, Your Honor.
All right. And do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, I do so stipulate.
All right. Mr. Brown, the terms of the recommended sentence would be that you'll be released within 24 hours once we conclude the plea hearing, that you would have to report to probation for the first visit, and then after that, it would be a non-reporting probation. I will waive your probation fees for that first visit. Would you like to proceed with the plea hearing?
Yes, but what about my belongings? I mean, everything that I own was in that house. I'm the victim here. And I spent
Right,
time in jail.
this is not a plea then. If you deem yourself to be the victim, then you are not admitting to the factual basis, and I have the absolute right to reject this plea. Mr. Brown?
I'm going along with it.
If you're going along with it, but you claim to be the victim, then how am I going to accept your plea?
I mean, I'm giving you the plea.
Your Honor, I don't think the state can accept that.
That is not a valid, knowing, voluntary, or willing plea.
I mean, I'm saying I'm guilty. If that's what y'all trying to say. I need to get out so I can do it in a civil way, so I can gain everything that I own. Everything I own was in the property. I need to get out so I can at least put a civil matter in so I can regain my everything that I lost. That's all I'm saying.
Your Honor, this sounds
how else do I get anything back everything that I own?
Your Honor, I think I need to speak, if I could speak with Mr. Brown in a breakout.
I guess I'm not understanding what's going on here.
If anything, it sounds more suited for a bond modification hearing.
If I could just speak with Mr. Brown on either if they could call a phone in courtroom 2 now that no one's here, or a breakout room to discuss this.
All right, go ahead. You can, we'll put courtroom 2 and 5 North into a breakout. And Mr. Pellin, unfortunately, we're going to hold until I address my competency calendar, which is now more than almost 2 hours overdue.
Understood.
Mr. Derek Howard, are you available, sir? Ms. Falk and Mr. Howard?
I am good.
Thank you.
I'm
And
here,
who's-
Your Honor.
All right, and who is our assistant? Who's going to be assisting you, Mr. Howard?
Kachi is on the line as well.
All right. Mr. Jordan, can you place, and Mr. Murphy as well, Dennis Murphy. All right, I think 3 South is a competency case, if I'm not mistaken.
That's correct.
All right, let's place 3 South, Dennis iPhone, Miss Shelley Falk, Mr. Derek Howard, Miss Kasha, and myself in a breakout, please. Thank you.
Are we still on SAP? I'm sorry.
They have one case to go, that last case that's on 5 North.
Yeah, it looks like the PD is speaking to their client.
Okay, no problem. Thank you.
Yeah, of course.
This meeting is being recorded.
And he gotta go pee pee. Yeah, too.
Not you. That's what I say, you could
Mr. Dotis?
Someone want to speak to the-
Yes, Your Honor.
All right, going back to Mr. Harry Joe Brown.
Yes, Your Honor, I spoke in depth with Mr. Brown. At this time, we'd actually ask to plead not guilty, waive arraignment, and address bond.
All right, 5 North, if you could please start the video.
Yes.
5 North, video, please. Thank you. All right, Mr. Brown's plea, the state's offer has been rejected. And so, Mr. Brown, we're going to, Mr. Dotis, your attorney, is going to file a waiver of arraignment in which he is going to acknowledge your not guilty plea on your behalf. Mr. Dotis, please submit the waiver to Miss April Champion. So we're going to mute 5 North, please, Mr. Jordan. And then we're going to address a bond modification. I believe Mr. Brown has got an $8,000 good bond at the present time. Mr. Dotis, you may proceed.
Yes, Your Honor. Do we want to hear from pretrial and the state first, or?
Certainly, if Ms. Tyson's available. Ms. Tyson, she's been very patient, so.
Yes.
All right, please, Ms. Tyson, on Harry Joe Brown, excuse me.
Yep. Mr. Brown, he has 10 arrest cycles beginning in 2010. He has no felony convictions. He does have a misdemeanor conviction out of Gwinnett County for willful obstruction and driving while license suspended or revoked. That's from June of 2013. His last arrest was out of DeKalb County, August 12th of 2023 for a misdemeanor criminal trespass. That case is pending. There's no disposition listed. He does have 8 arrest cycles out of Michigan beginning in 2005. And his last arrest in Michigan was in 2019, and that was for a traffic offense. No disposition is listed on the GCIC, Your Honor. Nothing to add.
Okay, thank you. Mr. Dotis?
Yes, Your Honor. Would Mr. Pellin like to go first, or I know I keep throwing people.
No,
on
it's
the-
your motion, sir, so.
Understood.
He's already got his $8,000 bond.
All right, just checking. Want to make sure everyone gets their turn.
Your Honor, I would clarify, my screen shows that it's an $8,000 cash bond.
Right, I was going to address that.
Okay.
Yes, Mr. Brown is 47 years old. He's been in custody at the Fulton County Jail for the past 14 days on an $8,000 cash bond for a criminal trespass charge. He cannot afford to pay that. As we heard from pretrial, it was no felony convictions. I have good contact information from Mr. Brown. He has been in the state of Georgia for the past 20 years. I do have a good address for Mr. Brown that is separate from the incident location. Mr. Brown is clear that he cannot return to the incident location. He does have a son who's currently at the address, which I will provide in the chat. It's in Decatur, Georgia, who's living there. But his father does provide financial stability. Mr. Brown works in the music industry as a sound producer. At this point in time, most of his income was through producing music, and all of his property was at the incident location. He's not clear what happened to that property and does not believe he has a livelihood waiting for him until he is able to secure that property or figure out where it is or get a replacement. So at this time, we're just asking for a signature bond.
All right. Mr. Pellin?
Thank you, Your Honor. State is strongly opposed to the modification of bond. I personally am confounded as to why this is charged as criminal trespass, but I realize Your Honor does have to rule on the charge as presented. As is stated in my statement of fact, the defendant occupied a vacant home that was for sale and then barricaded himself in the home, denying homeowner access to his own home. He was confronted with the fact that his lease was fraudulent. And not asked to move out at that instant, but asked to move out within 24 hours. He did not comply, instead tried to bar the homeowner. Your Honor, just for the court's information, I did look up the home at the provocation of our victim advocate. This home is being sold for $8 million and $8,700,000, which I worked out the math. I'm not a genius, but a 30-year mortgage payment for 1 month would be $25,000. So the idea that he had a lease agreement for $17,000 already doesn't make very much sense. Further, my victim incurred a $7,000 charge to remove the belongings that the defendant fraudulently put into the home. I don't think this case is appropriate for a signature bond. I would advocate that Your Honor keep the $8,000 bond.
Okay, I may be looking at this wrong, but it says surety bond. Where was the cash provision, or has this been amended?
Your Honor, I'm looking at the jailing screen of Odyssey, and when we print that out, if it was a mistake with the uploading it, but the jail is reading it as a cash bond.
I also looked at the jailing, Your Honor. So
All
given
right,
the
so
information you
the
presented-
record has to be amended to an $8,000 surety bond. That's what it says on Judge Williams' order. Okay, anything else, Mr. Pellin?
No, Your Honor.
All right. The bond is going to be modified to a 3,500 surety bond. Surety. He will have to go through a bonding company. He's to stay 500 yards away from the incident location. That's the length of 5 football fields. And that would be 50 Valley Road in Northwest Atlanta. Have no contact with George Duffield. Is it Overend?
That's correct, Your Honor.
All right. Although Judge Williams did give him a one-time visit with a law enforcement officer to get his belongings. From what I gather, the homeowner has already removed his belongings from the premises. So I am not going to grant a one-time visit. Mr. Dotis, your client would have to take the civil route to deal with any property loss at this time.
Thank you, Your Honor. Is this bond through the jail?
No, it's a surety bond, so.
Oh,
it's
excuse me,
either-
yeah. Thank you, Your Honor.
I was a little perplexed when y'all said cash bond when I had looked at the bond order, so if he was, that would clearly be a records issue.
Understood, Your Honor. I'll make sure that it is properly reflected this time.
All right, and you are also filing the waiver of arraignment, Mr. Dotis?
Yes, Your Honor. I'll send that shortly.
All right, and does he qualify for the services of the public defender's office?
Yeah, at this time, Your Honor, I believe so. It looks like he qualified at first appearance. And because he has been in custody, we are representing him, but if that changes in the future.
Where he had a lease arrangement for $17,000 a month?
Thank you, Your Honor.
Does he qualify, Mr. Dotis?
Your Honor, I'd have to look further into it. I'm not.
It's up to your office, sir. I cannot disqualify you if you all accept the client, but that's entirely up to y'all.
Understood, Your Honor. We usually don't qualify since we deal with in custody clients, but we'll make sure to double check that.
All right, a couple of things. Within 30 days, Mr. Brown will have to come back to the clerk's office and give us in writing his updated address, please. His current email, his current phone number.
You telling me you're Brown?
Anything
So
else,
within
Your
30
Honor?
days of being released, we'll need all these 3 elements submitted to the clerk's office in writing in person.
Your Honor, is that part of the bond?
Yes,
Great, thank you.
and if there are any changes, he needs to make sure that he provides the changes in writing as well.
Understood, Your Honor.
All right, that concludes this case. I think I am done. Unless anybody else has something else to ask. No, Miss Allen, Mr. Pellin, all right, I hope you all got to nibble a lunch, because I know Mr. Dotis didn't.
Judge Law, quick question.
What about Sutton on the compass seat?
Oh, that's reset to September 14th at 9 a.m.
Received.
All right. Thank you, sir. All right, everyone, y'all have a great Thursday afternoon, and we'll see you next week. Take care.
We'll see you.
Thank you. Thank you, everyone. Bye-bye.
Thank you.